Labrīt visiem! Sveicināti tie, kur ir klātienē, sveicināti arī tie, kur ir tiešsaistē. Un man ir liels prieks jūs visus šodien sveikt šajā konferencē Personas dati – nākotnes perspektīva. Šī nav pirmā konference, ko Datu valsts inspekcija rīko ar šādu nosaukumu, jo mēs vienmēr domājam, ka personas dati ir tas, kas ir tīri mūsējais. Viņas pieder katram cilvēkam, tā ir daļa no katra no mums, un nākotnē arī ir daļa katra no mums. Un mēs nevaram skatīties uz personas datiem ar pagātnes skatu, mums vienmēr jāskatās ar nākotnes skatu. Kas tad būs nākotne? Līdz ar to ik pa brīdim mēs rīkojam šāda veida konferenci. Šogad mums ir tāds dubult prieks, jo šogad Datu valsts inspekcijai palika arī 25 gadi. Vai tas ir tikai 25 gadi, vai tas ir jau ceturdaļa no gadsimta, to mēs vēl nezinām. Mēs to sapratīsim šodienas konferences laikā. Bet man ir liels prieks, ka jūs visi atradat laiku un iespēju ierasties šodien, vai arī attālināti veltīt mums savu laiku, būt ar mums šajā dienā, diskutēt par personas datiem ar nākotnes perspektīvu un tādā veidā arī svinēt mūsu jubileju. Šodien mums ir gana tāds, es teiktu, ļoti dažādi pasākumi. Mums būs diskusijas un paneli, mums būs arī grāmatas atklāšana. Un šodien, lai visus mūs iedrošinātu no tādas vadības politiskā viedokļa, pie mums arī atnākusi tieslietu ministre. Un es ļoti aicinu jūs nākt uz šejienu un sākt mums kādus vārdus. Lūdzu, tieslietu ministre Inese Lībņegnere.
Labrīt, cienījumā Datu valsts inspekcijas direktora Jekterina Macukas kundze, ļoti cienījumā tiesību sērdze Pākaus kundze, senatori, Datu valsts inspekcijas lieliskā komanda, visi klātesošie dāmas un kungi. Es turpināšu, ko Jekaterina tikko teica, 25 gadi ir gan maz, gan daudz. Un tur jau tas skaistums, ka mēs varam arī uz to palūkoties tieši no šodienas skatu punkta. Un savu uzrunu tāpēc arī bija domājuši sākt ar tādiem ļoti nozīmīgiem Raiņa vārdiem, kas zina, ko grib, spēj, ko grib. Jo tieši tas spilgti raksturo ne tikai mērķtiecību, bet arī stipras un vienotas komandas nozīmi. Un tieši šādu komandu Datu valsts inspekcija ir izveidojusi, un, manuprāt, 25 gados to tiešām nostiprināt. Tas ir ātri, skaidrs virziens, profesionāla atbildība, kopīga izpratne gan par tās būtisko lomu sabiedrībā, gan arī par to, ka tā ir konsultējoša, palīdzoša un tiešām jomu virzoša iestāde. 25 gadi tādā vienā valsts institūcijas dzīvē ir īpaši Latvijā nozīmīgs brieduma posms. Tas ir laiks, kurā ir iespējams ne tikai atskatīties uz paveikto, bet arī skaidri ieraudzīt, cik būtiski tad arī nākotnē mēs šo iestādi turpmāk redzam, cik daudz jūs vēl varat izdarīt gan cilvēktiesību aizsardzībā, gan arī visas sabiedrības uzticēšanās stiprināšanā. Un šodien, tādā laikmetā, kādā mēs katrs šodien dzīvojam, dati ir kļuvuši par vienu no ietekmīgākajiem resursiem, par tādu kā vienu no svarīgākajiem labumiem visā pasaulē. Tie veido pakalpojumus, virza ekonomiku, palīdz pieņemt lēmumus, veicina zinātnes, pētniecības un tehnoloģiju attīstību. Dati ir drošība, taču vienlaikus tie skar arī pašu svarīgāko, tie skar mūsu iekšējo katra cilvēka autonomo kodolu, cieņu, autonomiju, tiesības noteikt, lemt pašam par sevi. Un tieši tādēļ personas datu aizsardzība nav nec birokrātisks šķērslis biznesam, nav tehniska formalitāte, tā ir demokrātiskas, modernas un tiesiskas valsts pamatvērtība, tā ir arī Latvijas pamatvērtība, tā skar ikvienu cilvēku bez izņēmuma un gandrīz visas dzīves jomas, veselības aprūpi, izglītību, nodarbinātību, arī valsts pārvalde, digitālos pakalpojumus, finanšu nozari, zinātni un drošību un jebko vēl citu. Tādējādi tādu valsti, kādu mēs veidojam, tādu valsti, kur tehnoloģijas kalpo cilvēkam, un tādu valsti, kur inovācijas attīstās līdztekus atbildībai par tām, tādu valsti mēs varam izveidot kopā ar tiešām pārdomātu datu aizsardzību. Tā ir valsts, kurā cilvēks digitālajā laikmetā nejūtas mazāks par tehnoloģijām, nejūtas ievainojamāks vai nemanāmāks. Tāpat laikā netiek likti šķēršļi attīstībai, tehnoloģijām un zinātnē. Bet aizsargāt, cienīt un nostiprināt šo drošības sajūtu, tas ir jūsu datu valsts inspekcijas misija, un jūs to arī tiešām no sirds pildat. Šodien jūs kā iestāde, kas vienlaikus aizsargājat cilvēku pamattiesības, palīdzat veidot kvalitatīvu tiesisko vidi, skaidrojat, konsultējat, prevencijas ceļā novēršat riskus un veicinat atbildīgu inovāciju attīstību. Manuprāt, no Jekaterinas es tiešām esmu vienmēr arī dzirdējusi šo pamatprincipu konsultē vispirms, skaidro vispirms, domājot par to, kā biznesam, kā katram sabiedrības loceklim radīt šo sajūtu, ka jā, datu valsts inspekcijā ir sadarbības partneri. Un pēdējo 5 gadu laikā tieši datu valsts inspekcija ir strādājusi ar šādu uzstādījumu. Tā ir stiprinājusi gan uzraudzību, gan sniegusi atzinumus, gan arī piedalījusies normatīvu aktu izstrādē, konsultējusi, izglītojusi, palīdzējusi kopumā sabiedrībai orientēties ar vien sarežģītajā datu apstrādes vidē. Un nevien tikai reaģējot uz pārkāpumiem vai reaģējot uz problēmām, bet arī tiešām veidojot izpratni uz priekšu, un tas ir īpaši svarīgi. Jo tiesiska valsts nevar pastāvēt ar sankcijām vien. Tiesiskā valstī svarīgi ir cilvēki paši vēlas ievērot noteikto kārtību. Tiesiskā valstī ir izpratne, profesionāls dialogs un spēja savstarpēji novērst riskus. Un tieši tādēļ šodienas konferencē un tās darba kārtībā ir atspoguļots tas, cik plaša ir šī datu valsts aizsardzība mūsdienās. Un tāpēc arī domājot par mākslīgo intelektu, kas varbūt arī šobrīd katrā konferencē izskan no jauna, tas vairs nav tikai nākotnes jautājums, tas ir varbūt pat ne tagadnes, bet jau vakardienas jautājums, un mākslīgais intelekts un datu aizsardzība tādā kopsolī, tas ir arī mūsu visu kopdarbs. Jaunās tehnoloģijas, mēs zinām, nevar attīstīties ilgtspējīgi bez uzticēšanās. Uzticēšanās nevar pastāvēt bez skaidriem noteikumiem, bez profesionālas uzraudzības un cilvēka cieņas ievērošanas. Taču vēl svarīgāk, mums ir vajadzīga tāda valsts pārvalde, tādi valsts pārvaldes eksperti un zinošie cilvēki, kas ir gudri tiešām šai tehnoloģiju pārvaldībā. Paldies Datu valsts inspekcijai par visu, ko jūs esat darījuši, lai jums pietiek spēks, lai jums pietiek zināšanas un gudrība vienmēr domāt un redzēt šo vienu soli uz priekšu. Tas jau ir jūsu iestādes attīstības plāns, bet tas arī ir tas vēstījums, ko jūs esat nodevuši sabiedrībai, jūs esat nodevuši arī kopumā valstī par to, kāda ir valsts, kas raugās nākotnē ar tādu skaidru vērtību kompasu. Lai jums turpmāk tiešām būtu spēks veidot tādu digitālo vidi, uzraudzību, datu pārvaldību un aizsardzību, kur cilvēktiesības netiek pakārtotas tehnoloģijām, bet tehnoloģijas tiešām tiek attīstītas cilvēku labā. Visus sveicu 25 gadu jubilejā, tas ir skaists skaitlis. Un, lai izdodas to nosvinēt, es diemžēl došos uz citiem darba pienākumiem, bet turpināšu sekot konferencei attālināti. Paldies!
Kā jau minēju, šodien mums ir konference, bet ar tādiem neparastiem iestarpinājumiem. Un viens ir grāmatas atklāšana. Pateikšu jums godīgi, tā ir mana pirmā reize, kad es piedalos grāmatas atklāšanā. Lai mēs visi varētu atklāt to grāmatu un sakt par viņu runāt, un varbūt daļai no jums jau ir zināms, par ko mēs runāsim, es tūlīt aicināšu uz skatuves tos cilvēkus, kuri tieši strādāja pie tā, lai tā grāmata taptu. Sākotnēji es aicinu uz skatuves Tiesu nama aģentūras pārstāvjus Signi Terihovu un Lolitu Peku, jo tieši Tiesu nama aģentūra ir izdevusi šo grāmatu. Tālāk ir kārta, un jūs varat ieņemt labākas vietas un izvēlēties tās vietas, kuras jums patīk. Gan pirmo neaizņemiet, jā. Signa pirmo neaizņem, tajās apsēdīšos. Un nākamos es aicinu uz skatuves grāmatas zinātniskus redaktorus Jāni Plepu, arī senatoru, un Māri Ruķari, arī datu aizsardzības speciālistu, ilgadēju profesionāli. Un lai mums būtu nevis tikai tā mūsu datu aizsardzības speciālistu joma, mēs esam uzaicinājuši vēl vienu cilvēku piedalīties grāmatā atklāšanā un teikt savu viedokli visnotaļ objektīvo un profesionālo Edvins Danovskis, Latvijas universitātes dekāns. Un man ir tāds gods un prieks būt pirmajai, teikt kādus vārdus par šo grāmatu. Un grāmata ir vispārīgas datu regulas komentāri. 2016. gadā, un nu jau 10 gadi, īstenībā arī šogad datu regula ir daļais jubilejs, jo 2016. gadā datu regula tika pieņemta. 10 gadus mēs jau dzīvojam ar datu regulu, un kaut kādā 2020. gadā nākuši arī klāja Oksfordas universitātes komentāri par datu regulu. Man tikusi tā grāmata, es viņu pašķirstīju un padomāju, īsti nav nekas jauns. Un pēc būtības daudz, ko mēs spējam atrast jau apsvērumus regulas, mums arī pašiem Latvijā ir jurista vārda raksta datu aizsardzības speciālisti. Un tad es padomāju, ka mēs kā latvieši bieži vien nenovērtējam to savu nozīmīgumu un savas zināšanas. Un es padomāju, ka mēs Latvijā arī varētu izdot grāmatu, kura būtu krietni labāka, jo mēs viņu varētu balstīt uz praksi, uz savu pieredzi. Mēs varētu pieaicināt tos cilvēkus, kuri nevis tikai akadēmiķi, bet viņi reāli strādā ar tiem datiem un ar to regulu, jo daudzos gadījumos teorija višku atšķiras no prakses. Un tas, kas ir rakstīts teorija, bieži vien ir vēl jāpadomā, kā to pareizi īstenot praksēm. Un tad rādās doma par grāmatu. Uzrakstīsim grāmatu. Un tā mēs vērsamies pie Tiesu nama aģentūras. Viņi laipni piekrita šim projektam. Protams, projektam bija jāpabeidzās 2021. gadā. Kā jūs saprotiet, kā līdzvērtīgi daudzos projektos viņi ievelkās. Bet es teiktu, ka, manuprāt, tas ir labi, ka viņš ievilcies, jo kāreiz 22. un 23. gadā Eiropas Savienības tiesa nāca klāt ar daudziem jauniem spriedumiem, kuri mainīja mūsu priekšstatu par datu regulu, un mēs guvam jaunu iespēju uzrakstīt kaut ko labāku. Ja jūs ieminējat par Eiropas Savienības tiesu, tad grāmatas priekšvārdu arī rakstīja Eiropas Savienības tiesas pārstāvis, ģenerāladvokāte Laila Medina. Un sākumā mēs sāksim mūsu grāmatas atklāšanu ar Lailas Medinas video sveicienu visiem klātesošiem. Un tagad es lūkšu palaist to video sveicienu no Lailas.
Šodien es ar patiesu prieku sveicu Datu valsts inspekciju, tās direktoru Jekaterinu Macuku un visu datu aizsardzības entuziastus Datu valsts inspekcijas jubilejā. Darba pienākumi, diemžēl, liedz man būt kopā ar jums, lai svinētu padarīto un ar gandarījumu sajūtu lūkotos uz turpmāk veicamo. Jekaterina un mani vieno daudzi kopīgi darba gadi, tajā skaitā gadiem ilga interese par datu aizsardzību Latvijā un arī ārpus tās. Bet ir vēl kāds apvienojošs aspekts, kas ir īpaši svarīgs šodien. Tā ir pārliecība, ka dzīvē vajag abus – gan kārtīgi padarīt darbu, gan svētkus, jo priecīgi notikumi ir jāsvin. Inspekcijas gadsimta ceturkšnis sakrīt ar vispārīgās datu aizsardzības regulas 10 gadus jubilejas gadu, tāpēc jo īpaši prieks ir par dāvanu, kas ir sarūpēts šim svinīgiem notikumam par godu. Priecājos kopā ar plašo autoru kolektīvu šodien svinot grāmatas vispārīgā datu aizsardzības regula, skaidrojumi un komentāri nākšanu dienas gaismā. Tas nebija neviegli, ne ātri, bet beidzot varam teikt, mēs cēlām un uzcēlām. Datu aizsardzības entuziastiem Latvijā šodien ir liela diena, kad reizē tiek svinētas veselas 3 jubilejas. Iestādēji 25, regulai 10 un grāmatai pirmās dienas. Interesanti, cik svecītas būs uz šodienas kūkas? Rūpēties par datu aizsardzību ir sarežģīts uzdevums, it īpaši pasaulē, kur notiek nepārtraukta procesa un sistēma digitalizācija, un datu izmantošana ir ikviena cilvēka ikdiena un ir kļūsi par turpat vai neizbēgamu realitāti. Reizēm šķiet, ka datu apstrāde var likt blakus gaisam, ūdenim un ēdienam, tik nepieciešama tā ir. Datu valsts inspekcija ir pierādījusi, ka tā spēj stāvēt personas datu sardzē. Svētki ir brīdis, kad parasti atskatāmies uz notikušo, tāpēc pāris mirkļi no vēstures. Eiropas Savienībā personas datu aizsardzības regulējums ir iegājis savā gadsimta 4. desmitgadē. Pamatus šodienas sistēmai ielika 95. gada direktīva par personu aizsardzību attiecībā uz personas datu apstrādi un šādu datu brīvu apriti, uz kuras pamata tika būvēta iestāžu prakse un Eiropas Savienības tiesas judikatūra, kas vēl šodien diktē datu apstrādes pamatus. Piemēram, 2015. gada Eiropas Savienības tiesas spriedums Šrems lietā ir viens no datu aizsardzības izpratnes stūrakmeņiem arī šodien. Apskatot nākamo soli datu aizsardzības sistēmas attīstībā, ir vietā atzīmēt, ka tieši vispārīgās datu aizsardzības regulas izstrāde tā pa īstam savienoja Jekaterinu ar datu aizsardzības pasauli, jo tieši ar viņas rokām tika vilkti daudzi svarīgi otas triepieni datu regalas tepšanas procesā. Jekaterinas vadītajai komandai bija īpaša vieta, jo tieši Latvijas prezidentūras laikā tika panākta padomes kopējā pieeja, kas ļāva panākt gala vienošanos par regulas pieņemšanu 2015. gada nogalē. Jekaterinas atmiņas par šo laiku būtu ugunskura atmiņu stāstu cienīgs notikums. Regulai stājoties spēkā 2018. gadā, tās saturs ievērojami saviļņoja Latvijas sabiedrību. Tika organizēti neskaitām pasākumi, lai diskutētu, skaidrotu, vērtētu un prognozētu regulas nākotni un tās piemērošanu. No apsvērumiem par datiem kā jauno zeltu, līdz apgalvojumiem, ka datu aizsardzība pilnībā mainīs dzīvi un nedrīkstēs vairs itin neko, tik plašs bija dažādo viedokļu spektrs, kas virmoja par un ap vispārīgo datu aizsardzības regulu. Gadiem ejot, vētra ir norimusi un datu aizsardzības piemērošana ir kļuvusi par stabilu praksi ne tikai Latvijā un Eiropas Savienības tiesību sistēmās, tā ir ieguvusi plašu atpazīstamību visā pasaulē, kļūstot par galveno stūrakmeni diskusijai par Briseles efektu pasaules procesos. Datu valsts inspekcija šo gadu laikā ir būtiski izaugusi un ir arī mainījusies Latvijas izpratne par datu nozīmi ekonomikā, tiesībās un katra privātajā dzīvē. No jomas, kas interesē tikai dažus juristus, tā ir kļuvusi par horizontālu tiesību jautājumu, kas iestiepjas turpat vai katrā tiesību nozarē. Datu aizsardzība ir ieguvusi konstitucionālu rangu, kas tieši atspoguļojas Eiropas Savienības pamatiesību hartā, skaidri un nepārprotami ierindojot to pamatiesību ietverā. Tieši šī horizontalitāte un tās attiecināmība uz visām tiesību nozarēm padara datu aizsardzību par jomu, kurā vienas atbildes nav. Tas vienmēr ir vērtējuma jautājums, salāgojot datu aizsardzības principus un mērķus ar katru konkrēto situāciju. Izklausās sarežģīti? Tā tas arī ir, un tāpēc šodienas dāvana Datu valsts inspekcijas jubilejas reizē ir īpaši svētki. Grāmatas autora kolektīvs ir apkopojis gan teorētiskās apziņas, gan praktisko pieredzi, lai gandrīz 1000 lapas pusēs izstāstītu vispārīgās datu aizsardzības regulas stāstu. Studenti, pasniedzēji, praktizējoši juristi un valsts pārvaldē strādājošie, datu aizsardzības speciālisti un vienkārši datu lietotāji katrs varēs atrast padomu, ideju vai iedvesmu, kā risināt jautājumu, kas ir radies. Datu aizsardzībā priekšā uzrakstīts atbildes nav. Tā ir jāizsver un jāizvērtē katrā atsevišķā gadījumā pašam. Tas ir izaicinājums, bet tagad mums visiem ir palīgs, kas neļaus justies vienam datu aizsardzības risinājumu meklējumos. Daudz laimes dzimšanas dienā visiem datu aizsardzības entuziastiem!
Un no Eiropas Savienības tiesas mēs atgriežamies šajā zālē, kur mēs arī turpināsim runāt par datu aizsardzības regulas komentāru grāmatu. Es atļaušos pievienoties šim kuplajam un skaistiem cilvēkiem uz skatuves un tagad dot vārdu jums. Jūs, starp citu, varat izvēlēties, vai jūs sēdēsiet, jums ir mikrofoni priekšā, jūs varat iziet pie tribīnas, tā ir jūsu brīva izvēle. Mēs datu aizsardzību cienam cilvēku brīvu izvēlu, piekrišanai ir jābūt brīvai, skaidrai, neparprotamai. Un pirmo vārdu es došu grāmatas zinātniskajam redaktoram Jānim Plepam, kuram man liekas, ka šis bija gana tāds jauna joma, kura darboties, Jāni. Lūdzu.
Jā, labdien! Liels prieks redzēt ļoti daudz pazīstamas sejas. Tā kā, ja kādu nepaspēja apsveicināties individuāli, prieks jūs redzēt, lai superīga diena un daudz foršu ideju un iedvesmas. Jā, sanāca tā, ka zinātniskiem redaktoriem ir viena priekšrocība. Es, man liekas, to tekstu kopumā esmu lasījis apmēram 2,5 reizes. Respektīvi, tāpēc es varu zinoši teikt, ko sagaidīt vai ko tur negaidīt. Un runājot par grāmatu, man šķiet, Laila jau daudzas lietas pateica. Es gribētu dažus uzsvarus izdarīt, lai jūs pārliecinātu, ka tas noteikti noderēs. Un, grāmata izskatīsies skaisti ne tikai plauktā, īpaši Zoom saslēgumos aizmugurē. Ar viņu ne tikai varēs sevi aizstāvēt tagad šajos drošības laikos, jo ir pietiekami smags ķieģelis, bet arī jūsu ikdienas darbā un mūsu visu ikdienas darbā, jo no datu aizsardzības mēs neviens nekur nevaram paslēpties. Un tā pirmā lieta, ka nelielām tiesiskajām sistēmām ir jābūt nedaudz igauniskām, ambiciozām, pozitīvi lecīgām. Tādā ziņā, ka nevis teikt, ka mēs, tur Luksemburgā, tur labāk zinās, bet nākt un teikt, ka ziniet, bet mēs zinām kā, un mēs jūs pamācīsim. Un man šķiet, šis projekts ir raksturīgs tieši ar to, ka tas nav ieguldījums tik daudz nacionālās tiesiskās sistēmas attīstībā, cik Eiropas Savienības tiesību attīstībā. Jo tas ir jautājums par Eiropas Savienības tiesību akta piemērošanu, skaidrošanu, un Jekaterinas vadībā ļoti daudzi kolēģi, un šis patiešām ir kolektīvs veikums, tur nav tāda viena galvenā vai dažu galvenu autoru. Mēs visi kopā esam radījuši skaidrojumu, kurš ir aktuāls un piemērojams ne tikai šeit Rīgā, Latvijā, bet arī Portugālē, Grieķijā, Somijā, visur, kur piemēro regulu. Otra lieta, un šeit lieli komplimenti autoriem un arī kolēģis Signas Terihovas paveiktajam lasot tajā dialogā, jo par Eiropas Savienības tiesībām ir jārunā un jāstāsta un jāraksta latviešu valodā. Mums dažkārt liekas vienkāršāk angļu valodā, franču valodā, vācu valodā, bet šīs tiesības pastāv un darbojas arī latviešu valodā, kā oficiālajā valodā. Un tas nozīmē, ka mums jābūt kvalitatīvai juridiskai terminoloģijai, juridiskajai valodai, arī datu aizsardzības tiesībās, arī datu regulas piemērošanā. Un šeit tas darbs tika izdarīts. Mēs par šīm lietām runājam kvalitatīvā latviešu juridiskajā valodā. Tā kā, ja liekas kāds jēdziens, kur vajadzīgs, to var noteikti sameklēt. Tā kā tā ir tā otrā lieta. Un trešā lieta, Laila man šķiet nedaudz sabaidīja, sakot, ka to vienkāršo atbilžu nav. Mēs visi saprotam, ka dzīve ir sarežģīta. Tas tā ir. Bet šīs grāmatas galvenais uzdevums, manuprāt, ir visdrīzāk varbūt tiešām nebūs tā, ka jūs atšķirsiet 454. lapas pusi un tur būs tā atbilde, kas jums vajadzīga rītdienas dzīves gadījumam. Jo tā ir autora problēma. Tad, kad mēs rakstam, mēs nevaram iedomāties visu, kas notiks dzīvē. Un dzīvē visbiežāk notiek tas, ko mēs neviens neesam iedomājušies. Bet grāmata dod divas lietas, man liekas, ar kurām jūs droši varat virzīties uz priekšu. Viens ir izpratne, filozofija, vērtības par to, kas ir datu aizsardzība. Principi, vērtības, struktūra, kā uz šo jomu raudzīties, kā šajā jomā darboties. Un otra lieta ir metode. Atcerēsimies, ka mēs piemērojam Eiropas Savienības tiesību aktu. Šeit ir mazliet citas metodes, nekā piemērojot nacionālo tiesību aktu. Un šīs abas lietas grāmatā ir ļoti labi pārstāvētas, un līdz ar to faktiski, es domāju, arī kolēģiem Portugālē un Grieķijā varētu būt interesanti šo izlasīt, un liels paldies Iekaterinai par šo ideju, ambīciju un šodienas skaistajiem svētkiem, kad mēs esam atvēruši grāmatu, kas saturiski patiešām ir eiropeiskā līmenī, tādas, kādas ir angļu, čehu, spāņu valodā, un es tikai varētu novēlēt jums šajā nozarē virzīties uz priekšu, gādāt jaunus kāzusus, dzīves gadījumus, kurus pēc tam attiecīgi analizēs ne tikai Latvijā, bet visā Eiropas Savienībā. Lai viegls un raids grāmatas ceļš un jums forša konference.
Paldies, Jāni. Un tālāk es došu vārdu otrajam zinātniskajam redaktoram, kurš vienlaicīgi ir arī grāmatas dažu rakstu autors. Tu vari neko nedarīt, viņš pats sāks darboties. Un arī datu aizsardzības speciālisms. Tev tā kā nebija šī joma sveša. Tu jau tajā strādā, manuprāt, vairāk nekā 30 gadus. Tad ko tu vari par šo pateikt?
Jā, paldies. Te būs precīzi teikts, ka es strādāju ar šo jomu varbūt nedaudz vairāk, kā pastāv datu inspekcija, bet nedaudz. Var atklāt arī savus personas datus, ka principā te varētu būt arī 4. jubileja, bet tā ir personiska, jā, kad man ir nedaudz tieši tikpat vairāk, cik datu inspekcijai. Līdz ar to es esmu viens no tiem dažajiem juristiem, kas tajā laikā, teiksim, to strādāja. Bet, protams, ka šobrīd viss ir attīstījies un kur ir grāmatas praktiskā nozīme. Jo pavisam vēl nesen, tas ir salīdzinoši 7-8 gadu atpakaļ, jo es strādāju arī kā pārstāvis gan privātām institūcijām, gan valsts iestādēm, tad tiesā man vajadzēja attaisnoties tiesai, jo iestāde, kuras lēmums ir pārsūdzēts, pilnā nopietnībā apgalvo, ka viņa vispār nav pārzinis. Pārzinis ir tikai privāties sektors un valsts iestāde nav pārzinis. Un tas, man liekas, tagad būs savādāk, jo tātad pilnīgi katrs šīs jomas darbībā esošais, gan valsts iestāde, gan datu speciālists, kas viņus konsultē, gan tiesnesis, varēs atvērt šo lapus un izlasīt, ka viņi ir ne tikai pārziņi, viņiem ir arī kaut kādi pienākumi, un mēs redzēsim vienādi šo izpratni. Mēs varēsim visi vienādi izlasīt to, kas tur ir paredzēts. Tāpēc te ir liela praktiskā nozīme tieši arī nacionālā piemērošanā, un arī inspekcija varētu būt mazāk darba, jo kāds tagad izlasīs, ka nav jāraksta iesniegums vai, teiksim, nav jājautā kaut kādi jautājumi, kas ir zināmi. Tātad, paldies visiem kas piedalījās, un, teiksim, arī sadarbība bija, protams, nevienkārši, jo es varu nocitēt dažus Lolitas ēpastus man, teiksim, kur ir rakstīts, Māri, es ieraudzīju jūsu bildi jurista vārdā, bet atcerējos, ka jūs neko neesat atsūtījis un tam līdzīgi. Bet, protams, man liekas, ka tas ir pie visām grāmatas tapšanām, tie termiņi nav tik vienkārši ievērojami, it īpaši pie šāda liela autoru skaita. Es domāju, vēlreiz, teiksim, uzsverot šo izdevumu nozīmību, es atceros, ka pirmie komentāri, kas vispār Latvijā iznāca, manuprāt, bija par civilu likumu. Un tad tas bija liels notikums, jo tāda žanra izdevuma juridiskajā literatūrā nebija. Un es domāju, ka šo izdevumu var pielīdzināt aptuveni šādam notikumam, jo tieši datu aizsardzībā mums nebija vienota tāda pēdējā laika izdevuma. Neskaitīsim tos vecos manus tur, kā saka, mēģinājumus, kas arī bija, protams, tam laikam varbūt derīgi, bet šobrīd pēdējo 10 gadu laikā un tā tālāk mums nav bijis tāds izdevums, un viņš ir pielīdzināms tāda laika notikumam, kā toreiz, teiksim, tie civila likuma komentāri. Jā, mums ir bijuši dažas publikācijas jurista vārdā, bet, pieņemsim, atkal, ja ir runa par profesionālo darbību, tad ne visi var sameklēt šos rakstus vai apkopot, un līdz ar to šis vienotais izdevums ļauj tagad visiem izmantot, un teiksim, arī tāda lieta, ka kopējā tiesību laukā nevar būt šie robi. Pieņemsim, ja kādreiz ir runa par informācijas atklātību, tad pretī ir arī svaru kausu šis datu aizsardzība. Ja pastāvēs tikai atklātība vai tikai datu aizsardzība, tad arī šis līdzsvars nepastāvēs, un, manuprāt, arī šī grāmata piedāvā, kā saka, paskatīties, kā šis līdzsvars būtu meklējams, atrodams un piemērojams dzīvē. Tā kā es domāju, ka mēs arī sagaidīsim droši vien atsauces turpmākajos spriedumos, kā saka, arī no tiesas puses uz šo izdevumu. Paldies visiem un sveicu arī Datos inspekciju jubilejām.
Paldies, Māri. Un, ja līdz šim pārsvarā visi tie, kuri runāja par grāmatu, bija tie cilvēki, kuri piedalījās tās tapšanā. Un kā mums katram, ziniet, savs bērns, viņš ir visskaistākais, vislabākais, visgudrākais un viss kaut kas. Un tagad ir skats no malas. Un es gribētu dot vārdu Edvinam Danovskim, kurš nepiedalījās grāmatas tapšanā, līdz ar to var būt ļoti objektīvs attiecībā uz šo grāmatu un izteikt savu viedokli. Edvin, lūdzu, vārds jums.
Tā, labdien, godājumie klātesošie. Kad Matsukas kundze man aicināja arī šodien piesakot sniegt objektīvu un profesionālu viedokli par šo grāmatu, tad man uzreiz te uz vietas radās pirmā asociācija ar filmu, kur arī jūs droši vien lielākā daļa esat redzējuši. Saucās Misters Beans, kur viņam ir jābrauc uz Ameriku, jūs ziniet, un kā lielam speciālistam un jāsaka kaut kas par gleznu Vislera māte. Un tā es šobrīd jūtos, sakot kaut ko objektīvi un profesionāli par šo grāmatu, un ko es varu teikt, pirmkārt, šī grāmata ir bieza. Ne katra grāmata var nodarīt miesas bojājumus, bet šī var. Otrkārt, es biju patīkami pārsteigts uz vāku ieraugot arī divus lieliskus kolēģus, par kuru talantiem man nebija nekāda šaubu, bet kuri mani pārsteidz pirmkārt ar to, ka man šobrīd būs ļoti viegli atrasināt jautājumu, ja kādreiz Jekaterina netiks uz kādu lekciju, tad es zvanīšu Jānim un palūkšu, vai viņš nevarētu nolasīt kaut ko par pārrobežu datu aizsardzības jautājumiem vai tam līdzīgi. Un savukārt kolēģis Māris Ruķers, arī mans brīnišķīgais ilgadējais kolēģis, viņš pats par sevi pieteica, ka viņš ir šajā profesijā tik ilgi, kad es jau sen biju zaudējis cerības viņu vēlreiz ieraudzīt uz kādas grāmatas vāka, par ko es esmu ļoti priecīgs, vai ne? Bet par šo grāmatu man ir vēl divas asociācijas, ar kurām es gribētu padalīties. Pirmā, man gribētu tos uzsvērt, ar ko vēl šī biezā grāmata, ir vēl divas citas biezas. Pirmā ir Boļeslavam Prusam ir tāds romāns Faraons. Šajā romānā viņš ir par seno Ēģipti, par vienu jaunu faraonu, kurš nonāk tronī, un viņš grib gudri valdīt, arī ievies dažādas reformas un tā tālāk, un tad tur ir tāda priesteru kārta. Un šie priesteri ir ļoti ietekmīgi, ja viņiem ir zināšanu monopols, jo viņi var dažādi izskaidrot, piemēram, saules aptumsumu, labi zinot, ka viņš pienāks, bet to var tikpat labi arī pasniegt kā ļaunu vēstošu ilūziju vai kaut ko tam līdzīgu. Un šajā romānā, pasaules slavenajā romānā, ir brīnišķīgi parādīts, kāda vara ir tiem, kuriem ir monopols pār zināšanām. Datu speciālisti ir tādi mēģinājuši būt zināmu laiku, bet man liels prieks, ka viņi paši šo zināšanu monopolu ar šo grāmatu, vismaz latviešu valodā, ir zināmā mērā novērsuši ar šīm zināšanām daloties, vai ne? Un līdz ar to arī mēs katrs, kuram ikdienā, mums šeit dažādās profesionālās kapacitātēs, mūsdienu jurists, protams, nespēja vairs iztikt bez tās, saprotiet, Eiropas datu regulas un viņas normu sapratnes, tādēļ katram dienu ir šajos jautājumos jāiedziļinās un zināma deva no tā, kas regulāri sarakstīts, jāizcieš. Un otra grāmata, kas man ienāca prātā arī šajā tematā, pat mazliet plānāka, šeit 916 lapas puses, vēl pirms 2018. gadā iznāca Harijam Tumanam grāmata Varoņu un varonība senajā Grieķijā, 896 lapas puses. Un te atkal man gribētos zināmu līdzību uzrakstīt vai nē, bet katrā ziņā runāt par varoņiem un varonību mūsdienu Latvijā. Un uzrakstīt šo grāmatu, ziniet, tas ir varoņdarbs. Vispirms jau es zinu, ka šī grāmata ir tapusi ilgus gadus. Es zinu, ka tiesnama aģentūra un arī pieredzes bagātā redaktora Signe Terihova ir lielu darbu ieguldījusi ar visiem autoriem kopā. Un, jūs saprotiet, grāmatas uzrakstīšana tā nav viegla lieta. Vispirms jau tās ir radošas mokas, bet arī tā ir zināma ziedošanās vispārības labā. Jo jūs domājat, kad ir kāds milzīgs, mantisks ieguvums rakstot grāmatu vai kaut kas tam līdzīgs? Nē. Ir tikai ziedošanās citiem, apziņa, ka tas, ko jūs esat izdarījuši, citiem būs noderīgs. Un galu galā arī tāda cerība, ka šis varoņu darbs cilvēkiem būs noderīgs ilgi, jo ilgi. Ja. Es pats esmu arī jau izlasījis ne visu grāmatu, bet daļu gatavojoties arī šodienas diskusijai. Un varu pateikt, ka tur var atrast atbildes uz ļoti daudziem praktiskiem jautājumiem, tā kā paldies autoriem par šo varoņu darbu, kas mūsu tiesību sistēmu šajā ziņā atkal vienu lielu baltu plankumu nosedz ar labu darbu. Paldies par to.
Paldies, Edvin. Un tagad es gribu dot vārdu divām sievietēm, no kura ēpastiem pēdējos 3 gados es baidījos visvairāk. Jo tajā brīdī, kad es redzēju mana darbā ēpasta iekritot šos vārdus, Lolita Peka vai Signa Terihova, es tā ielpoju, izelpoju, jo es arī biju autors, es biju diezgan nekārtīgs autors, līdzīgi kā Māris, un tad es arī dabūju diezgan daudz atgādinājumus par savu darbu, un tad no Signes es dabūju vēl atgādinājumus par savu darbu, no Lolitas atgādinājumu, ka jāmēdi citi autori, un man kaut kā bija jārēģē uz viņu ēpastiem, nevienmēr man to gribēs darīt, un jā, bet tas nenozīmē, ka es nenovērtēju jūsu darbu, jo, jūs saprotiet, tajā brīdī, tad, kad ir 3. gads, tu zaudi cerības un vajag kādu, kurš tevi virza un motivē tālāk. Jūs bijat tas virzītais spēks un motivatori, un tagad kā jūs jūtaties tajā visā? Jūs varat tur iet, šeit iet, tā es...
Bet izturēja taču tomēr visas mokas. Jā, man ir liels prieks par šī grandiozā projekta veiksmīgu noslēgumu. Un es jau tā kā esmu jau citos projektos, tad man arī visas sāpes un arī pagājušas. Jā, grāmatas tapšanas process bija ilgs, toties pamatīgs un rūpīgs. Autoru daudzveidība, daudzskaitlīga, atšķirīgā pieredze grāmatu juridiska satura rakstīšanā, atšķirīga izpratne par termiņiem, kā arī bieži nesaudzīgā kritika, tiecoties pēc pilnības, projektu paildzināja. Vienlaikus, kā jau te tika norādīts, laika nobīde ļāva izmantot aktuālāko normatīvo regulējumu un arī jaunākos avotus, tostarp Eiropas institūciju dokumentu latviskojumus. Tā kā prieks par panākumu, mums izdevās tomēr grāmatu pielāgot arī jūsu skaistajai jubilejai. No sākuma sarunām ar Matsukas kundzi, man liekas, kādā no Bīriņas semināriem mēs runājam par varbūt rakstu krājumu par šo tēmu un tā tālāk, bet viss tas materializējies 910 lapušu biezā un 1,5 kilogramu smagā grāmatā, drukātā formātā. Un par to es ceru gandarījums ar visiem iesaistītajiem. Lai arī darbs uzsākts pie komentāru rakstīšanas sen, es personīgi iesaistījos laikam kāds pēdējos 2 gadus, kuru laikā spēju nokaitināt noteikti nevienu autoru. Arī man šī bija liela pieredze strādājot ar jauniem rakstniekiem, ar akadēmisko vidi un tiesu institūcijām mazāk saistītiem autoriem, no kuriem vairumu es noteikti tagad redzēšu pirmo reizi, jūs droši vien mani arī pirmo reizi redzēsiet. Tāpēc no sirds atvainojos visiem tiem, kuri jūtās aizskarti vai morāli cietuši gan no manis, gan no citiem redaktoriem. Tomēr ceru, ka šī kritika noderēs jums turpmākajā rakstniecības darbā. Tiesnām aģentūra kā juridiskās literatūras izdevēji, kur grāmatas citstarp izmanto gan tiesas, gan topošie juristi, kvalitātes latiņu esam uzlikuši ļoti augstu. Tostarp arī prasību maksimāli izmantot gan tekstos, gan terminoloģijā latviešu valodu. Tāpēc vēl jau vairāk prieks par šo rezultātu samērā jaunajā tiesību nozarē, kas ir svarīgi mums visiem. Paldies jums visiem! Jācer, ka grāmatu novērtēs arī mērķa auditorija, datu speciālisti, juristi, ierēģi, ik viens interesants. Grāmata pie lasītājiem savu ceļu sāka marta sākumā, un šī nepilna mēneša laikā to jau ir iegādājušies vairāk kā 150 cilvēku, precīzi vakar bija skaitlis 168. Tā kā interese ir, un es domāju, pēc šī pasākuma būs vēl lielāka. Jā, tās cena nav maza, taču tirgus ekonomikas principos balstītā speciālās literatūras izdošana nevar būt lēta, īpaši Latvijas apstākļos, kur mērķa auditorija grāmatām ir visai ierobežota. Jo lielāka metiena, jo cena labāka, jo metiena lielums atkarīgs no pircēja ieinteresētības. Grāmatas cena atspoguļo tās sagatavošanā ieguldītos materiālos un finanšu līdzekļus un vismaz daļēji arī ieguldīto intelektuālo darbu. Un tikai pateicoties grāmatas projekta atbalstītājiem, tās cena var kļūt maksimāli draudzīgāka. Un tāpēc vispirms Tiesnama aģentūras vārdā gribam pateikties šī projekta atbalstītājiem.
Tātad par grāmatas saturu jau daudz kas bija pateikts, tāpēc es vēlētos vērst jūsu uzmanību uz to, ka šāda mēroga izdevuma sagatavošana un izdošana prasē ne tikai autoru un zinātnisku redaktoru akademisku pienesumu, bet arī nozīmīgu finanšu ieguldījumu. Tāpēc es vēlos izteikt vislielāko pateicību mūsu projekta sponsoriem, kuri ar savu lēmumu atbalstīja šo projektu un, respektīvi, atbalstīt šo projektu, viņi sekmējuši juridiskas domas attīstībai. Lūdzu, liels paldies Berg advokātiem, Zverināto advokātu birojiem. Vai jūsu pārstāvis ir šeit? Jā, lūdzu. Liels paldies arī Zverināto advokātu birojam Rode un partneri par viņu lielu nozīmīgu atbalstu. Jā, lūdzu. Un, protams, vēl pateicamies arī Zverināto advokātu birojam Sarainen. Vai ir pārstāvis? Liels paldies vēlreiz visiem mūsu atbalstītājiem. Jā, un tad tālāk.
Jā, šis projekts, protams, nevarēja pastāvēt bez tā iniciators. Un es domāju, vispirms vislielākie pateicības vārdi ir pašai mūsu Jekaterinai Matsukai. Un, protams, vislielākais paldies arī zinātniskajiem redaktoriem. Un tieši pateicoties Mārim, šī grāmata kļuva arvien aktuālāka un aktuālāka. Un, protams, grāmata nebūtu bez autora darba, un tāpēc es gribētu kopā ar jums uzgavilēt visiem grāmatas autoriem. Es nosaukšu visus alfabēta secībā bez jebkādiem grādiem. Tātad paldies Irēna Barkāne. Paldies Anna Bogdanova. Vismaz es varu arī apskatīties uz jums, un jūs uz mani tuvāk. Paldies Lāsmai Dilbai. Paldies Olgai Graudiņai. Paldies Evijai Kreišmanai. Paldies Ivo Krievam. Viens no autoriem, kuram daudz dabūja ciest. Paldies Laurim Linabergam. Nu jā, viņš arī ļoti cieta. Labi. Paldies rakstniecei Jekaterinai Matsukai. Paldies Sanitai Petersonai. Laikam nav. Jā, nav. Paldies vārda māsai Signai Plūmiņai. Paldies rakstniekam Mārim Bruķerim. Paldies Veronikai Sajādovai. Viņa cieta pirmā. Paldies Viktorijai Soņecai. Paldies Julijai Terjuhanai. Paldies Annai Vladimirovai Krjukovai. Un paldies Danai Voitiņai. Vēlreiz paldies visiem. Reklamējam grāmatu, ātrāk pārdosiet, ātrāk dabūsiet honorārus, ātrāk izdosim papildu metienu.
Paldies jums liels, bet man ir prieks, ka mēs esam, ziniet kā, grāmatu mēs rakstījām ilgi, bet attiecībā uz atklāšanas pasākuma laiku mēs esam ļoti precīzi. Tas ir brīnišķīgi. Mēs kaut ko mācamies, tas nozīmē, bet mums vēl paliek pēdējās 5 minūtes, un tad iespējams kāds no autoriem vēlas kaut ko pateikt par savu pieredzi, vai piedalīsies vēlreiz šādā pasākumā, nepiedalīsies, vai... Tas nav piespiests, brīva piekrišana, bet iespējams kāds vēlas pateikt kādus vārtus. Nē. Viņi visi ir pateikuši grāmatā. Bet man ir vēl viens, jo mums tikko visus autorus apdāvināja ar puķam, bet es gribētu arī uzdāvināt puķus tiešām Signei un Lolitai par to motivāciju, neatlaidību un tā kā darbību, lai tomēr no idejas un tādā autoru iedoma, kā mēs gribam kaut ko redzēt, tas pārtāptu par reālo darbu, gan zinātnisko, gan, ka mēs noskaidrojam arī drošības un aizsardzības līdzekli. Un uz šīs svinīgas nots mēs varam noslēgt grāmatas atklāšanu un turpināt konferenci. Un te ir neliela uzmanībā gan tiem, kur ir klātienē, gan tiem, kur ir tiešsaistē. Tie, kurie ir tiešsaistē, jums tāda, es teiktu, būs 5-10 minūtes neliels pārtraukums, kurai jūs redzēsiet šo tukšo skatuvi, jo mēs klātienē mēģināsim pārkārtoties. Tie, kuri ir klātienē, šodienas konferencē mums ir 3 paneļi. Viens panelis nākamais ir šajā zālē, līdz ar to tie, kuri iepriekš izvēlējas vai kuriem vēl joprojām ir iespēja paskatīties programmā un izvēlēties šo paneli, kas būs šeit par mākslīga intelekta, datu izmantošanu mākslīga intelekta trenēšanā, var palikt šeit. Bet mums paralēli notiek arī vēl 2 paneļi, kuri arī ir viens no paneļiem šobrīd ir skatāms tiešsaistē, un viņi notiek klātienē 2. stāvā. Jums ir jāaiziet no šīs telpas, jāiet taisni un tad jāuzkāp uz 2. stāvu. Tur būs 1. zāle, kur jūs varat paklausīties un varbūt arī piedalīties diskusijā par datu aizsardzības prasībām tiesību aktu projektos. Un 2. zālē trešajā zālē, turpat otrajā stāvā, būs arī tāda praktiska nodarbošanos, izspēle atrast hakeri. Līdz ar to tie, kuri vēlas darboties praksē, var doties uz trešo zāli. Tie, kuriem ir vairāk interesē tiesību aktu projekti, var doties uz otro zāli. Tie, kuriem interesē mākslīgais intelekts, var palikt šeit. Un jau pēc 5–10 minūtēm mēs sāksim visus paneļus. Paldies jums liels! Un paldies vēlreiz aplausi mūsu grāmatas atklāju komandai. Lūdzu, uzkavieties fotogrāfijai šeit pat. Jūs varat? Var paņemt viņu līdzi, vai ūdeni, vai kafiju, vai tēju. Un no grāmatas atklāšanas mēs turpinām ar nākamo paneli. Un tā kā nākamais panelis mums ir angliski, es arī pāriešu uz angļu valodu. Dear guests, dear listeners of this conference online and all the participants, we start our panels. And the first panel today is a panel about artificial intelligence. It's not surprising, you know. Everybody talk about the artificial intelligence, I think, last 2 years. I would say, if before, when it was 2016, when GDPR was adopted, sexy topic was GDPR. Everybody knew these 4 letters. Nowadays, in 2024, 2025, and 2026, the new 2 sexy letters, AI. We want to do everything with AI, we want to develop it, we want to live it, but sometimes we are a little bit afraid of it as well. We think that it could be threatened, we do not know how it goes in our lives, and that's why, and I mentioned before that our conference name is Personal Data Future Look. So we want to talk about the future and about the future which is now a little bit. If we talk about the artificial intelligence, we talk about it as well on personal data, how we can use our personal data in it. Is it legal? Is it not legal? Is GDPR, for example, applicable for the training of the artificial intelligence? There's a lot of questions. Sometimes we get on them answers, sometimes not. And that's why today we try to collect different people to talk about this, because in many cases, you know, data protection authorities talk among themselves, and they know the truth. The IT companies and technology specialists, they talk about themselves and they know the truth, and of course they know that there's those in the government or parliament, they do not write, they do not really think. Then there is a data protection specialist, privacy lawyers, they talk about themselves and they know the truth, they know how to do it, but all these other technique companies does not know anything. So we tried to collect all these people together on one stage to talk to each other and listen to each other's perspective on the artificial intelligence. And so I will call out the panelists of this panel for the stage. First of all, we will all come together and then each panelist will give their own presentation, their own view of the topic, and then we will have the discussion. And I hope we will not fight. So I will ask on the stage Julia Terihana, who is Data Protection Officer and as well Master of Arts in Information Technology. Applauses, please. Yeah. The next one, the representatives of the private sector, of the technical companies, and those who do it in practice. Liga Ignate, Executive Director of the Latvian Digital Accelerator. Please applauses. And the next was Gatis Romanovskis, member of the board of the Artificial Intelligence Latvian Association and AI expert. And I want to notice, I really like the abbreviation of the Latvian Association of the Artificial Intelligence, because in Latvian it's Mākslīgais Intellect, which means ME, so it's Mila, and Mila in Latvian means love. So you see, we go with this with love. Then I will ask on the floor Olivier Mater, Head of the International Cooperation of the European Data Protection Supervisor. And Olivier will give us, I would say, the thoughts on what EDPS thinks about the artificial intelligence and personal data training in this field from the Data Protection Authority point of view, because I will be moderator, you know. Today I'm quite, I will try to be objective and out of my position. And next one, the person who has to combine everything in Latvia, at least, with each other, Guna Pulce, head of the Artificial Intelligence Center of Latvia. Each of you, will have possibility to present your view on the topic. And Julia, I will give the floor to you as a first speaker.
Hello, everyone. It's a pleasure to be here, and thank you for inviting me. My task today is to tell you more about whether it is possible to train AI with publicly available data. On my daily basis, I work as a technology lawyer at an insurance company. I wear multiple hats. I'm also a lecturer at the university and also focus specifically on AI-related topics. But the main question is, if data is public, can we freely use it for AI training? And the question is, yes, but GDPR still applies. And there are main things which have to be kept in mind, that always, those are like no-brainers and the basics, that always we have to have legal basis for processing, and also the purpose of processing. And when choosing the purpose of processing, remember that freely available data was collected with a different purpose than AI training, mainly. And when selecting the purpose, when we open the GDPR commenter, then we remember that this other purpose, which we select over the time, then it has to be closely related to this initial purpose. And this is the challenge. We cannot just invent new purpose out of thin air. The next purpose has to be related to the initial purpose of processing. The challenge is the transparency. Imagine a situation when data is publicly available, but data subjects are completely oblivious. They don't know who and why wants to process data for AI training, and there is no way for them to find out typically. Because even if the company processes the data and publishes privacy policy, all of you know how it works. It's somewhere under the hyperlink, and somewhere in the text there is 1 or 2 sentences that we process data for AI training. Also, remember that also in this situation of training AI with publicly available data, data subjects still have their rights, right to object, right to erasure, right to receive proper information about how data is being processed. And here we balance innovation and fundamental rights and think about in which situations particularly we can still use the data for this processing purpose. It's not black and white, it's always contextual. And first let's take a look what the publicly available data is. We can imagine that it's social media content which we publish, which we share with. Also, different forums online where, for example, customers provide feedback that this product is great or this service has been awful. These are also public registries like company register, land register, register or database of publicly available court decisions. It can be data sets which are being scraped from the internet. Scraping in general is not prohibited, but certain rules apply. And these can be open data portals provided by member state governments. Some web pages specifically prohibit scraping, and it is also done by technical means through specific files which are incorporated in the web pages, like in this last point you see robot.txt or AI.txt files, and specifically indicate in terms and conditions that they do not support scraping from this particular web page. And this also has to be taken into account technically when planning such scraping, if you do so. Then there is also AI Act specific layer, but it is very thin and very not wide, let's say so. AI Act prohibits specifically scraping for the purpose of creating databases of facial images, and the keyword is also untargeted scraping, meaning that you don't know specific group you are targeting, you just do it without any particular reasoning why and why specifically those people. Just scrape everything you can to create those databases. This is prohibited practice. And AI Act also addresses training, but specifically in high-risk use cases. And to be honest, most of the use cases which are on the market, and this has also been admitted by the European Commission, most of the cases are not high risk, most of them are minimal risk or maybe limited risk. So let's see the general possibility, not focus on high risk today. Core legal challenges, I have mentioned them at the start, and now let's go into depth. Purpose limitation. First, you think, is it compatible purpose? And it is especially problematic when scraping is being made on a large scale. And remember, when we choose the purpose, also think of legal basis. And legal basis for AI training based on publicly available data typically is legitimate interest. Yes, legitimate interest requires LIA, data DPOs know what it means. It's legal impact assessment, specific documentation where we balance the rights of data subjects versus our, as organizations or companies' interest to process certain data. And there is balancing test, which also considers how data subjects access the information, how this purpose is well balanced with the initial purpose, and also if it's large scale data processing, remember Article 35 DPIA, and LIA can be part of DPIA. With AI in general, the tricky aspect is that AI, the way how it works, sometimes contradicts the GDPR. Because GDPR has been created 10 years ago without AI in mind, and AI is working without GDPR in mind. This is just how the technology is shaped. And there is possible so-called sensitive inference, basically when AI can, based on non-sensitive data, create a sensitive profile of a person, for example, can determine political views or some medical condition of a person based on different other aspects which are not sensitive data. And as I mentioned, lack of user awareness. And when we balance it in LIA, in the legitimate impact assessment, there also have to be considered ways how we strengthen data subject rights. And later I will show the slide as well. There has been, not so fresh anymore, it's from 2024, EDPB, European Data Protection Board's opinion how data subject rights can be strengthened, for example, by providing longer periods how they can exercise the rights or do not apply limitations required by the GDPR for erasure of data or right to object, and just allow data subjects to do it, to request it, irrespective of the time or irrespective of the existence of preconditions. But as we can imagine, and those who work with AI, oftentimes right to object or right to erasure is quite an impossible mission in AI. If we can imagine the process, first we collect the data, then we sort out the data, and then we train the model. Then in the process of collecting and sorting out what data sets we have, it is still possible to erase data or stop processing it based on the request of objection. But once the AI model has been trained, it's practically impossible to take out the data. And if we do so, it basically would require to retrain the whole model. Imagine a situation, like let's jump already to the biggest ones, like OpenAI models. If they receive hundreds and hundreds of requests, then it would be a mission impossible to retrain such a huge models. It would be just business relevant and take so much resources, and nobody would do that, and nobody does it. So basically, it has to be noted that right to erasure and right to object, it's practically impossible to do. Also, it has to be reminded that if we process sensitive categories of data, Article 9 still applies. Here we cannot use legitimate interest anymore. And here, you know, the basis for data processing, I cannot imagine that it would be processed based on vital interest, for example, or provided by law. So in this case, probably the consent and publicly available data and consent is quite an impossible situation unless it has to be obtained at the very beginning of obtaining data from the original source. But let's jump over it. Speaking of the data subject rights, right to be informed can be skipped when we process data indirectly obtained from the data source, which is basically the case of publicly available data. It can be skipped when it requires disproportionate effort. And it's a way out of the obligation, but at the same time, the EDPB emphasizes that there can be ways of informing data subjects, for example, publishing information online on the web page or spreading out newsletter via email. But again, not in all situations it is practically possible. And as I mentioned, right to object, when and how. If a company scrapes the data online, has a privacy policy which says you have right to object, you will never find it. And even if it's relevant in the stage when data is still being collected, it is very difficult to actually match the individual with this time frame and the actual right to object. Probably many of you have heard about developments in the European Court of Justice case law, and this is a so-called SRB case from the end of the last year. And this is a tendency which also can somehow help to use personal data available online for AI training purpose. It basically strengthens and establishes so-called relative personal data, meaning that for some controllers, this can be personal data and GDPR applies, but for the others, taking into consideration the context and the means they could use to identify subjects, if they can't, then it can be called relative personal data, and this other controller may treat this data as non-identifiable, basically anonymous, and in those cases we know GDPR does not apply. And in this particular situation, there was a SRB who used Deloitte as an outsourced company and shared pseudonymized data with them without informing their data subjects. And Deloitte claimed that there was no way for them to identify actually those pseudonymized subjects behind the data they received. And the court agreed. Basically, for Deloitte, the data was non-identifiable, but for SRB, it was still identifiable. This is a tricky situation. It requires a lot of documentation and also technical measures, but it is possible to reach this situation. And the same approach is visible in the EDPB's opinion from 2024, which I already mentioned. Here on the right side, it says the model is anonymized if using reasonable means, the likelihood of identification of individuals, whether extracting data from the model itself or the output, if the risk is very low, then basically the model is anonymous and no GDPR rules apply. But again, the threshold is high, and this is the way how we could potentially simplify this. And the same approach reflects in EU Digital Omnibus, which is a legislative initiative many of you have heard about. It is currently in the process of public discussion, and there also this emerging concept of impersonal data has been included, which is influenced by this SRB decision, also previous influence of the EDPS decision, and also even previous court practice. So basically, data is not fully anonymous, but in certain circumstances, when all the technical and organizational means are implemented correctly, then data can be somehow moved outside the scope of GDPR and also used for training of the AI. Basically, we don't know how it will be adopted. There are many things included in the EU Digital Omnibus besides the GDPR clauses. Let's follow. But the answer to the initial question is whether we can use publicly available data. Yes, we can, if we implement specific technical organizational means, if we are clearly aware of data subject rights, and do our best and what is suitable for the situation to actually meet the GDPR requirements. At the same time, we need to be conscious that it is not always possible. Thank you.
Thank you, Julia. And now, because in the first part of our panel, we will listen to each other. And so then next, I will give the floor to the technology people who do it in the practice. And please, Gatis, your floor is yours. Then you will change with Liga and you will add each other. And we listen to the data protection specialist's point of view. Now we want to listen about the practical point of view.
Yes. Hello, thank you. And yes, first of all, also greetings in your anniversary. So it's really a pleasure to be here. And yes, I will try to make slightly different scope due to I'm not a data specialist. I'm more, let's say, technician, and based on that, I will maybe try to explain you in the quite simple language how does actually AI works, yes, and also what kind of principles we need to understand so to follow what kind of data we are inputting. Yes, so actually, if we are talking about this this learning process, actually the AI engine without data, it's actually useless. So there's nothing. It's just a way how it can, let's say something memorized. I will give very simple example. Let's assume we are loading for AI 3 types of vehicles. There's BMW, Volvo, and what was last? I can't even see from there. It's Audi. Yes, and we are giving, like, I don't know, 1,000 pictures from the each car type. There are different cars from the different years, and so. And it recognized that this is the way how needs to look BMW, this is how needs to look Volvo, and this is how needs to look Audi. And then if we will give the picture of one of these 3 cars, even it's also other model, we will show BMW, most probably AI will tell that yes, it looks more than BMW, and it will answer yes, this is BMW. In same time, if we will give as a sample, so there are Mercedes, but engine don't have any recognition about, so he never saw the Mercedes. Most probably he will tell it looks closer to which type of these 3, what kind of actually this knowledge they are having. And this is very, let's say, simple principle on the moment when we are saying, hey, it's not BMW, but this is Mercedes. Starting from that point, the system will have already, let's say, 3 types of vehicle, yes? And based on that, this is how everything is growing, but for sure I'm talking right now only with 3 car brands, but we need to keep in mind that there needs to be plenty of data, and on that moment it becomes quite complicated. The second thing what I would like to express you, this is how actually the search engine works, and it's like, what does it mean, let's say, embedding or vectors, yes? If we remember how this, let's say, Google search works, we are looking for the special keywords, yes, or the part of the word. But when we are talking with AI, actual world, we are giving for each item, say, different shapes, or they called or they called vectors. As a sample, if we are sticking to the same, let's say, cars, we can take BMW third class from 2000, and it's, let's say, it drives with fuel, and we can put so different these vectors. And based on that, if we will change some of these vectors, let's say we are changing the year from 2000 to 2020, and from engine to, let's say, from fuel to electricity, most probably we will be somewhere very close to, I don't know, Tesla maybe, yes? So this is how it looks. Maybe other example, if we are taking, let's say, king, we can also put different, we can put different vectors. Let's say this is some middle age, this is rich, man, let's say 65 plus, yes? And in the same time, if we are changing some of the vectors, as a sample, we are changing from man to woman, and age from 65 to 25, most probably we will get princess, yes? And this is how these vectors works, actually. And the next very important thing is the temperature, or let's say creativity of AI. And this is where we are able to play and work on these, let's say, recognitions. If we will ask, please, I even made some example, with the temperature 0, it means so AI is not, let's say, creative at all. It will only put together what he has. If I will ask, please join the Mercedes and BMW logotype, this is what we will get. So the first picture, we will get simple 2, let's say, logotypes. And if we are increasing the temperature, then they will be more and more mixed, yes? And this is also very important on the moment when we are working with data. We need to understand, if we are willing for very precise and very, let's say, accurate output, even with some legislations or something like that, we need to use this temperature as low as possible, yes? Very frequent, even 0. But in the same time, if we are using AI for, I don't know, some creative tools or marketing, then most probably our temperature will need to be higher. And yes, also about this purpose, it's do we are able to use the same trained models for different purposes? It's yes, we can, but it's not the best actual case how we are using. As a sample, what I show on the first slide, these vehicles, if we will use the same model and start to recognize the animals, most probably it will be fully mess. Yes, but in the same time, we need to try to stick and train each model for each purpose, and this is the way how we will be able to get most accurate systems. In the same time, on my last slide, so usually what we are doing or where we are getting the data, this is, let's say, the publicly all available this information, and it's quite messy. Yes, so there's plenty of opinions, and based on that, it's actually quite complicated to train precise models. In the same time, if we could have, let's say, some governmental sandboxes where we are having like specially prepared data for the trainings, then definitely also these models will work much more precise. And then I will switch on that point. Yes, so League will continue.
Hello, everyone. Yes, thank you, Gatis. So we will switch over and circle a little back to the first speaker. And also, as previously mentioned about those sexy words, GDPR and AI, currently they are actually afraid of each other. They try to stick away one from another because of these, because of consent, because of legitimate interest, because of special categories, because you have to provide the right to opt out. It is very difficult for those who are working with these technologies to implement all of this and to stay to keep their focus on what they want to reach, and also not connected with GDPR, but also intellectual property rights. They are also afraid of that because there are a lot of problems connected with these legal aspects, and it is technically very complex to implement these and ensure for the data subjects to actually opt out of it, give a consent, clearly understanding why are they using my data to train this model and what will be the outcome, etc., etc. So it is very complicated for those who are developing AI tools. But speaking about the Latvian situation and why do we need models that are trained on Latvian data, we might say that just use data from UK, use data from USA, wherever, you know, why do you need Latvian data? But the thing is that if we don't train it with local data, those models will be absolutely inaccurate if we want to use them here in Latvia. So also we have to take into account the linguistic barrier, that our language is unique. There is actually, to be honest, there is not many data to train models on Latvian language. You know, we have only as many books as we have. And training models requires a lot of data, trillions of data sets, etc. So, of course, it depends on the reason, on the aim of the module, what it will do, how much data it needs, but actually it really requires a lot of data. And yes, as I mentioned about the linguistic barrier, we have this in our project where Digital Accelerator is working currently. We provide support for companies training and doing new digital projects and also cooperating with public sector. And so we had Tilde working with the Constitutional Court, and they are currently trying to create a Constitutional Court AI that helps to write the determining part of the court adjudications. So the introduction of the court, you know better than I do. So, and yes, and they had to train it on a local data in Latvian because, of course, if we would use data from, I don't know, Lithuanian courts or whatever other courts, you know, the outcome wouldn't be accurate. The outcome, the text wouldn't sound Latvian and it wouldn't look Latvian. And to train this module, they had to use the data, all the data that the court had since the 1996 when it was actually established. So every court decision was put in this module, of course anonymized and etc., for the data to be legally used there. But it just shows the amount of data needed to train those modules and why we have to use Latvian data in Latvian language. For it to be used in a Latvian court, it has to be trained on our data. And if we want to support our GovTech, if we want to implement those technologies, if we want to use AI in our everyday work and help to develop our services that government provides us, it requires using our own data. And maybe sometimes it can be frightening, but it is how it is. And yes, about this. And another example with data and Tilde, they also worked with the development agency of Latvia, and they needed data from as a third party. Data provider was the Office of Citizenship that holds the data about our addresses. Where we are registered. And so it is an AI tool meant for the latvia.go.lv, where we can fill out our applications for some services, and it just finds automatically our addresses, so we don't have to fill it in ourselves if we don't know where is our registered address or whatever. The problem here in this situation was that it involves a third party. The data holder is someone from the outside of the group, someone not really interested in training this AI. It took almost 4 months for Tilde and Leah to discuss it with the citizenship citizenship office to have this data, for them to understand why Tilde needs this data, how this data can be cleared and anonymized, and how it really can be used. So there were a lot of questions to ask and to be answered to get this data. So what we see here is the problem in Latvia we have, that if we want to use Latvian data, we understand that we have to use it, but there's this really mixed feelings on this, how to provide this data, when it is safe, what data can we give and what we cannot. And all those offices that are holders of the data, they are guarding them because they know it's their responsibility. They're holding to the data with all their hands and feet. You know, they won't give it up easily. So for the companies to create a module working with Latvian data, they have to somehow convince those offices to give this data. And actually, there are so much misunderstandings and not clear answers how to actually do this. So when I was talking with Tilde and others who are developing AI in Latvia, what we understand the problem is that we really need safeguarding data is very important. Of course, we want our data to be safe, and we want to understand where our data is used. We don't want situations like in China when data is government's and you don't get a say about where your data is used and how it is used. You don't own your data. Here in the EU, we own our data. We can give our consent or opt out from things, you know, but, and it is very important that we have this right. But still, if we want to support innovation, if we want to move forward, we have to find a way how to balance both those things, innovation and data safety. So that is the big question for us, and for us, like being the middle part between those developers and between those offices that have those data and that are actually interested in using AI and having those modules that would help them in their daily work. And yeah, our idea of the action plan is like that. You have today the book explaining the GDPR, and that's great, that's perfect. And we might have the book as well, the second book, on how to ask for data, how to provide data for those who are developers. In which cases, maybe we can categorize the data, which is more safeguarded, which is not so safeguarded, which is more easily given away for those companies, you know, and somehow put this in boxes and give a commentary in which cases, which questions are to be asked, which companies can get the data, maybe some, you know, safety requirements for the companies, etc., etc. So, and of course, keep the human in the loop, you know, because that is, let's not fully rely on the AI because, you know, there has to be a person who is responsible for the safety, who is responsible for the actions that the AI does, etc., etc. But yeah, my message today mostly is that data is needed to train local agents that help us do our work and go through our days. And we have to find a way how to get it safely, how to provide it to the companies, how to find the balance in all of this. Thank you.
Thank you, Liga. Thank you, Liga. And now, from the practitioners, we go to the European Union level and to the EDPS, and I know that one of the priorities of EDPS is as well artificial intelligence and how to compare it with the GDPR. So, Olivier, the floor is yours. What you are thinking from the EDPS perspective of the personal data usage in the AI training?
also celebrated our anniversary, our 20th anniversary 2 years ago, and we also did a book. So I really understand the extra work that this implies, so congrats for that. It means also that we will always be 3 years younger than you, and it's always nice to be invited to a birthday party. I'm one of them. You have a lot to learn, and I'm very eager to listen more from the practitioners in the field, also about the Latvian specific situation. I'm not sure everyone is very familiar with what is the EDPS, so the European Data Protection Supervisor. So let me just recall that this is the data protection authority of EU institutions. So we supervise the Commission, the Parliament, the Council, but we also supervise the around 80 institutions such as Eurojust, Europol, Frontex, or EU LISA that is in charge, for instance, of large-scale databases in sensitive matters. We also advise the Commission on any aspects in relation to data protection, and we are a member of the European Data Protection Board, together with the Latvian DPA. And so we are a DPA for 22 years, as I mentioned, but we are no longer only a data protection authority. And I just wanted to mention, to start with, that under the AI Act that was adopted recently, the EDPS is also now a market surveillance authority for AI systems used by EU institutions, and we are a notified body for certain high-risk AI systems. And if you have an interest, you can look at our website. We have several initiatives to explain what we do to be ready for these new, very new and challenging tasks. We launched a strategy. We established a specific AI unit within our offices. We already did a mapping of AI systems undertaken by EU institutions, showing a lot of projects, for instance, in the law enforcement sector, on HR, for instance, purposes. We are currently establishing, through a pilot phase, a regulatory sandbox to try to test the implementation of AI system. We have a network of AI correspondents, etc. So if you have an interest, we even made a compass to explain a bit our vision and strategy. But I'm not here to speak about our role under the AI Act. I'm here to speak about the legal grounds for the training of AI models. And I will try to share a few perspectives from the EU, and I would say mainly from the GDPR perspective, that is perhaps the most interesting here. I think it's obvious to say that AI and data protection are heavily interlinked, that AI needs to be fueled by a massive quantity of personal data. But I think the first message I want to pass is that yes, the GDPR remains the starting point whenever there is processing of personal data in the AI system. And I think the legal structure that we have that is very familiar, I guess, to all of you, that you need to comply with the golden rules of Article 5. You need a legal basis under 6. You need to comply with the stricter conditions for special categories of data. You need to give rights to the data subject. I mean, this legal structure applies fully to AI whenever there is a use or processing of personal data. But now let me try to zoom in a bit and for my presentation focus on the question of legal basis. So focusing on Article 6 of the GDPR. I think we have 6 legal bases there, but I think it's also fair to say that consent most often will not be the most appropriate legal basis, especially in cases, for instance, around scraping, where data is collected indirectly at a very large scale. There is no direct relationship between the entity developing an AI system, and data subjects are not even aware that their data have been published or processed. So very quickly, and often for private company, the discussion is about the possibility or not to rely on legitimate interest, so on Article 6.1f of the GDPR. And we have a European answer, and I think it was mentioned in the first presentation. There was this opinion, 28/2024, adopted in December 24, that I think gives a nuanced answer, that yes, entities may rely on legitimate interest, but that's not a default permission. And if you agree, I will just try to dive a bit deeper into the content of this opinion. Of course, it relies on it builds on the guidelines on legitimate interest that were also adopted by the EDPB, that recalls that you need 3 steps. The first one, you need to have a legitimate interest. The second one, the processing needs to be necessary to pursue that interest, and then you have the so-called and sometimes very delicate and challenging balancing exercise. So the first one, legitimate interest, that's not to be confused with the purpose, but it's very linked. I would say it's broader. For instance, the court made it very, very clear that a commercial interest is a legitimate interest for this first layer. Of course, the interest has to be lawful. So here you need to check whether you have some prohibitions, for instance, in the Digital Services Act, for instance, in the AI Act. The interest has to be clearly, precisely articulated, real, present, not speculative. And in the opinion I mentioned, the EDPB is giving a few examples of what is a legitimate interest, developing a conversational agent to assist users, developing an AI system to detect fraudulent content or behavior, or improving threat detection in an information system. That's the first step. Second step is about the necessity. That's, I think, very familiar to the data protection practitioners in the room. You need to check whether the processing activity will allow the pursuit of the purpose and whether there are no less intrusive means to fulfill that purpose. And so here you need to take into account and pay attention to the amount of data processed and whether it's proportionate to pursue the legitimate interest at stake, also in light of the data minimization principle. And so if you speak, for instance, about scraping, if you can train your AI model in an efficient manner using only synthetic data, well, that means that it's not necessary to go to the, I would say, non-pseudonymized or non-synthetic data and the full personal data. So that's step number 2. Now, step number 3, that's often the most challenging one, it's the balancing test. So here, again, you need to put in the balance your own interest or the interest of a third party that you are pursuing and the interest of the data subject. You need to assess also the impact on the data subject. Here as well, the data subject interest may be very, very diverse. It may just be the willingness to retain control over your personal data. It may be a financial interest, a personal interest, etc. You also need to pay attention that you should not go in a situation where data subject would just fear a sense of, I would say, general surveillance, because data would be out there, it would be inevitably scraped and used. So this may lead to self-censor, it may even lead to attempts on the freedom of expression. When it comes to the risks, of course there are many, but controllers need to be mindful of the risk about attacks on the model where personal data may be retrieved. You need to be careful about the reputational risk, the identity theft risks. You need to be careful about the possible creation of deepfakes with the model, about chatbots that would be used for disinformation, about manipulative AI agents, etc., etc. When you're done with this step, you also need, in the legitimate interest assessment, look at the reasonable expectations of data subjects. That's often a very difficult one, because it's not easy to try to guess what the data subjects are expecting. I think here the first trap to avoid is to consider that because you informed the data subject, then he may expect the processing. So in other words, to put very well hidden in a privacy policy one line that you will do that and that would be enough. No, I think it's a more objective assessment that has to build on different parameters. The place and context of the data collection, the nature of the sources that you are using, whether the data are publicly available or not. I'm sure we'll go back to this later on in the discussion. You need to take into account also the characteristics of the data subject. The expectations may vary if you speak about minors, if you speak about public figures, etc. And so when you are done, you have a sort of balancing. Sometimes the weighing may not be so much in the favor of the controllers. And here, the EDPB is also developing on the fact that you may consider adding some mitigating measures that may go actually beyond your mere legal obligations. It would be extra measures to limit the impact on the data subject. And I think here these opinion, in my view, is well made and useful because it contains good examples of technical organizational measures that may help in this discussion. I mean, the first series of measures, of course, would be to exclude certain collection of data in the first place. For instance, excluding the collection for persons that would have a particular risk. You know, I'm thinking, I don't know, about the humanitarian context. Be careful there. You want to avoid, for instance, collection of data from websites that are opposing to the web scraping through some protocols, etc. You want to exclude special categories of data. You may go for measures to mask personal data or to substitute it with fake personal data in the training set. You may go for privacy-enhancing technologies, use of pseudonymization. You may go for increased transparency measures, so go beyond what is in Article 12 to 14 of the GDPR, like have some public reports, give details about how you trained your model, go for even campaigns via email, go for diagrams, graphics to explain in an easy manner what you're doing. Another example is to give sufficient time between the time of the collection and its use. That's often useful then for the data subjects to exercise their rights. The EDPB is also speaking about an unconditional right to object that may be given to the data subject. About giving the possibility to the data subject to exercise the right to erasure, even though we are not in the specific grounds of Article 17 of the GDPR. You may also go in the deployment phase about, output filters to avoid the fact that personal data would be inferred from the system. You may go towards digital watermarking of AI-generated output. You may do some post-training of your model to remove or suppress the personal data. So a list of measures, very comprehensive. But again, it's a case-by-case assessment, sometimes a bit frustrating, but this is, I would say, the key messages of this opinion. So, I mean, I focused very much on the question of legal grounds, on the legal basis. Does this opinion solve everything? Certainly not. That's not my, my point here. There are a lot of gray areas that remain. I think the EDPB is aware that more guidance, and it's only guidance, it's one part of the answer, is needed. And in their work program, the EDPB members already say that they are going to work on guidelines for web scraping and also on the interplay between the GDPR and the AI Act. I will soon reach the end, but one point I also wanted to make is that it's not only for the regulator to give guidance. The legislator may also step in. And I think it was mentioned already in one presentation, there are some heated discussions these days around what we call the omnibuses. So there is the AI omnibus, so with proposal to change already some aspects of the AI Act, and discussion on the digital omnibus to change other documents, other instruments in the digital rulebook, including the GDPR, including a proposed change to the definition of personal data, so to the core of what is our regulation, that the EDPB and EDPS, by the way, strongly opposed in a joint opinion. But in this digital omnibus, there is one proposal by the Commission saying that we may specify in the GDPR that legitimate interests may serve as a legal basis for the development and operation of AI system. And here the EDPB and EDPS, in a joint opinion, were basically saying that this is not really needed. It doesn't have, it doesn't change the legal situation because this was already clarified in the opinion I presented. But there is one aspect of the proposal that is interesting and that should be taken on board by the legislator. The process is still ongoing. It's this unconditional right to object that would be given to the data subject that may, for instance, fit rather in Article 21 of the GDPR. So, long story short, I focused on legal basis. I think legitimate interest can serve as a legal basis, but never automatically, never without a rigorous assessment of legitimacy, necessity, balancing, transparency, and effective rights. And it's also very, very much about the safeguards that will be put in place. And I think, just to conclude, I think one of the main strengths of the data protection regulation is that it's built on very broad principles that are with us, I think, since the 70s, that didn't change that much since then. And it's sometimes frustrating because it implies a case-by-case assessment, but I think it also gives the flexibility that is needed to adapt to new technologies, to new realities. AI is one of them. We had other challenges before. We will have other challenges in the future. And I think this requires some pragmatism on the side of the regulator when we approach this question, but it also requires a real commitment on the side of the practitioners, on the side of the industry, to take privacy very seriously from the beginning and to invest in finding solutions on how to comply as well. And that's it.
Thank you, Olivier. And I think that this legal basis for me, and here at Cal, always put my hat of the Data Protection Authority hat, legal basis is the most important one. If you do not have legal basis, then everything else doesn't matter, if honestly. If you're informed, if you does not inform data subject, so you have to have this legal ground and legal basis. And we will talk about this later in the discussion, but now I want to give the floor to Guna, who is quite tough, I would say, task, because she's the head of the Artificial Intelligence Center. So private sector comes to her saying that we want, and as well the holder of the first sandbox. So private sector comes to her and saying, like, we want to develop AI, but then she has as well to say, like, but we have as well law. So you have to be good to everybody. It's quite hard.
Yeah, it's a very hard position. Hello, everyone. Nice to be here. Thank you for the invitation and congratulations with your anniversary. And yes, we are living in a moment where artificial intelligence is developing faster than many of our institutions, habits, and legal interpretations can comfortably follow. And of course, it creates a natural reaction, caution. And caution is understandable. In many cases, it is necessary, but if caution becomes our only response, then we risk misunderstanding the real challenge in front of us. Because the real question is not whether AI will continue to develop. It will. The real question is whether we will be prepared to guide that development in a way that is lawful, responsible, and genuinely useful to society. That is, in my view, this discussion should not be framed as a choice between stopping AI or allowing it. That is already the wrong starting point. The better question is how do we shape the conditions under which AI can be developed and used responsibly. And too often public discussions about AI begins with fear. Fear of surveillance, of discrimination, opacity, human control, losing human control, and fear that systems will be deployed before institutions are ready to understand or supervise them. And I would say these concerns are not imaginary, they are real and they deserve our attention, but fear is a poor basis for the strategy. If fear becomes the dominant political and institutional instinct, then we create culture in which hesitation replaces judgment and avoidance replaces governance. And that would be a mistake because AI is not going away and it will continue to advance across different sectors, across borders, across continents, and across public and private institutions. So the task is not to pretend that this development can be frozen. The task is to ensure that it unfolds under conditions that protects the rights, builds trust, and creates public value. And this is where the role of the AI Center becomes important. AI Center can
help create exactly the kind of environment that is needed now. One that supports innovation, but does it with the legal awareness, ethical seriousness, and institutional responsibility. This role is not technical, it is organizational and strategic. The AI Center can help bring together expertise, guidance and cooperation, and can reduce fragmentation. It can support public institutions and other actors in moving from uncertainty to implementation. And it can help make sure that the national conversation on AI is not driven only by abstract principles or fears, but with practical pathways. And if we are serious about practical ways how to move forward, then we must speak also honestly about data, and this was already mentioned today, that there is no meaningful AI without data. And if we are talking about AI that is genuinely useful in a real societal, economic or public context, then in many cases this also means personal data. And this may be an uncomfortable conversation, but avoiding this does not make it less true. And the issue is not whether data matters. Of course they matter. The issue is how data can be used responsibly, proportionately, and all the other principles already mentioned from this stage. And too often the conversation stops at prohibition. Of course, legal limits matter, rights matter, safeguards matter. But if we speak only in the language of what is forbidden, we also end up in the dead end. So the more useful question is what is the path forward, a lawful path forward. And these are the questions for what purpose data is being used, what are the legal bases, is the use necessary, proportionate, and responsible, and how that responsibility is demonstrated in practice. So these are not abstract legal questions, they are the real conditions for the responsible innovation. And if we want that AI development be both lawful and useful, then this is the exact level in which the discussion needs to happen. But at the same time, of course, the risks are real. We have risks of discrimination, that data use expands beyond its original purpose, privacy risks, security risks, and there's always a risk of losing public trust. So responsible AI does not mean denying the risks, but it starts with the readiness. And very often the biggest obstacle is not that we have some bad intentions. The biggest obstacle is that organizations do not fully know what data they hold, how those data move, what exact purpose it serves, and whether less intrusive alternatives had been properly considered. And so the way forward is, of course, with sound data governance, data mapping, impact assessments, and clear analysis on necessity and proportionality. And we have to have different safeguards in places, and it requires enough institutional maturity to ask not only what is technically possible, but what is justified and sustainable. In my view, this is where the progress often slows down, not because people are against innovation as such, but because there is not enough AI literacy, not enough procedural clarity, and not enough early dialogue between innovators, regulators, and institutions. So, and in this case, a lot of projects become stuck in uncertainty because questions are asked too late, risks are identified too late, legal concerns appear too late, and by that point, the trust may be already under strain. So the real task is to define how can we move forward lawfully, safety, how can we test solutions safety, and how can trust be built from the beginning rather than repaired at the end. And this is why we need to be not first our reflex is
not doing some things, but we have to find answers to the question, how can we move forward? And one practical tool here is the regulatory sandbox. Sandbox, the first, what the sandbox is not. So it is not an exception to the rules. It is not where the place where regulation is switched off, and it is not a shortcut around data protection. Sandbox is a structured environment in which innovation and oversight can meet earlier. It allows solutions to be tested safely, it helps identify risks sooner, and it creates earlier communication between innovators and regulators. It reduces uncertainty before large-scale deployment. So this is good for all the involved parties, for innovators, because the clarity we have sooner, and it is good also for regulators because it allows issues to be identified at the right stage. And it's also good for the society because it increases the likelihood that AI systems will be introduced responsibly. And this is also where the AI Center can play a very important role, not just with the expertise, but by helping to build this enabling environment for responsible implementation. So, in my opinion, we have to frame our discussion around these topics. So first, as I already mentioned, we should not set data protection and innovation against each other. So this is the false choice. Of course, we should not ignore the risks, but we should also not allow our fears of the risks to become a culture of inaction. We need to move from abstract debate to practical pathways, so the legal clarity, sound governance, early cooperation, and responsible testing. So this is the practical steps we can take already today. And of course, we need more capacity, institutional, organizational, and human, to implement AI responsibly. So these are, in my opinion, real challenges, not whether AI should exist, not whether risks exist, not whether law matters, but whether we are capable of building the conditions under which innovation and responsibility can move forward together. Yes, so I will stop with the real question, whether we will be ready to guide this AI development well, in the public interest, with responsibility, and with enough practical capacity to move forward. And I hope that AI Center can bring this into life, because this is a new organization in Latvia. We are doing a lot of things for the first time, and I think if all the stakeholders involved, we can have success. Thank you.
Thank you very much, Gunnar. And I really hope that you will have the success, because you would be this point of view when everybody will come together, and as well Data Protection Authority, other competent authorities, private sector, and in these regulatory sandboxes, at least where you will be this guided force to force these people to come together. I have prepared questions, of course, for all of you and for the discussions, but before we start the whole discussion, I have some special questions for each of you. And I would start with Olivier, and I would ask you about what are the most misunderstood point in the current debate of the AI training and the personal data, what you see from the supervisor perspective. What is what we all, or maybe private sector and even governmental sector, are afraid of, and this is not that you have to be afraid of?
Thank you for the question. It's a great question. I propose that we take 2 days to discuss about it, because it's a very broad one. And I think I will pick on the last point that you made, that it's not right against innovation. I think this is really a real misunderstanding that we have today in a lot of political debates, that apparently there is one race towards innovation, and that would be incompatible with the regulation, that innovation needs to go fast, needs to break things, and that regulation is just an obstacle. I think we really need to get rid of this narrative. And I remember, for instance, the Draghi report about competitiveness of the EU, which says that we need to go for caution and innovation, both at the same time. And we need to reach a good balance. And I think the European way to go towards innovation has to be anchored into non-negotiable values and rights, and data protection is part of them. And I think it was even the Commissioner Vestager, former Commissioner for Competition, that said that, when she was pressured about these imperatives, that we need to let the Chinese be Chinese, we need to let the Americans be Americans, because we Europeans would be lousy Chinese, would be lousy Americans. And they are just much better at it. And I think this notion of race towards innovation and towards regulation, I think kills a bit what is at the core of the digital regulation, which is that we need to find a balance, and we need to find a compromise between conflicting interests. Another point, and here a bit more general, if I may. I was more technical in my presentation, more legal, but I think for me one very important misunderstanding is that we should also not ask too much to the law and to the data protection law in particular. I think if you look at the impact of AI on our societies, it's just huge. And it goes way, way, way beyond what we may, as data protection authorities, discuss. I mean, the impact, the world of AI is controlled by few very large firms. And we need to ask ourselves whether AI is serving the interest of everyone, of only the few that control it. We need also to question the link and the relation we have with the technology. We need to ask whether actually this technology is leading to a situation of dependency, where we actually delegate our competencies to AI, and that would be problematic. And I'm French, and I will just make one quote. And I'm a bit philosophical sometimes, and there is a French philosopher, Montesquieu, that say that you first need to learn the Latin language, and then you need to forget it. But what matters is that you take time to learn the Latin language, because this is the capacity to learn that you absolutely need to get, and that you cannot delegate. So I think the point I want to make is that the discussion is way broader than what we may discuss in data protection circles or even in AI innovation circles. I think it's also about the link we have with the technology, and this requires also some ethical discussion or even political choices, that in the Greek sense of it, how we want to organize the life of the city. So on this one I was a bit more general, but for me this is also part of the misunderstanding.
Thank you very much. And the next question for me will be to Julia, and it will be somehow similar, but from the philosophical point of view to the practical point of view, you as a data protection specialist, you consult as well the private companies. So what the legal weaknesses you see in the organizations when they try to justify personal data use for the AI training?
Okay, then if we go back to my presentation, then probably we go to the very beginning when we try to find a legal basis, its legitimate interest, and then we think of the purpose, and the purpose oftentimes comes later than initial collection of data, and it can be incompatible, and then companies try to justify and try to squeeze out this purpose, and sometimes those legitimate impact assessments are formalistic. They are just created for the sake of being, without actually assessing all the necessary steps which are required. The balancing of rights and the possible additional measures, how data subject rights can be strengthened by the means so mentioned from the EDPS opinion. The documentation sometimes is created for the sake of just being. This is the weakness, because if the actual supervisory authority checks it, it is just a document without
actual justification. This is the problem.
Okay, thank you very much. And okay, I cannot afford myself, but yes, as data protection authority, I can say that this is real thing. When companies, they do some legal assessments or DPAA and just our aim to write something there. And sometimes it doesn't rely on what the company does in the reality. And then you have to go to the company and say like, but please tell truth. Maybe this truth is not so bad. And that's why my question is to Gatis. From the technical point of view, how this is realistic to separate, for example, personal data from non-personal data, or how it's realistic to make some trainings on the anonymized data?
Yes, so it's actually quite a complicated question. Technically, if we are looking, so it's even if we are removing from data all the private information, still we can use some kind of, let's say, tides how to put it together, and then based on that. So anyway, so it will not be so fully let's say anonym, yes, and then and based on that, it's really that from that perspective. And if we will give data which is fully encrypted, then again we are not able to train. So it's somewhere in the middle, yes. And based on that, it's yes, it's very hard to tell where we can get such data, yes. And from that perspective, this is the way what we also mentioned about these sandboxes, that there are special place, special data where we are able to train all these models.
Okay, but sometimes, and here I always look at this about what we are talking about, and Olivier mentioned this big companies who hold now the like known and big AI tools, but nevertheless here in Latvia we try to develop our own. They does not hold so, and they're not so great, but we want them out for ourselves and maybe to compete a little bit with this big companies. And that's why my question goes to Liga, who helps private companies to do it. Which these specific types of training data or use cases currently create this legal uncertainty for you, for the smaller ones, not so big ones, but if you want to create something new here in Latvia?
Yes, thank you for the question. I think the biggest uncertainties are always about how to ask for the data and how to collect it correctly for it to really not create those legal struggles, legal problems for the companies. That's why, as I mentioned in my presentation, our local companies, they tend to avoid using public data. They stay away from it, personal data, because it creates a lot of questions. But to create a local model, as I said, about our local situation, about that we have quite small amount of data actually available in our country to create something for us to be used here. So it is crucial to use this data, but then again, how do you ask it? How do you collect it? Whom do you ask it? Who holds the data? And if he has the data, how can he give it to you in a legal way and give this data clear enough for you to use it on training the AI, because very often it is way more easy for the officers, the holders of the data, to just, okay, take it if you want it. Here we have some packages of data, you can have it. Well, of course, I'm trivializing it, but in a sense, but then the company has to sort out what data is there, what do I actually need, and then the question is, who does the sorting? If it's the office who holds the data, then it requires a lot of work to sort out the data. It requires understanding which data is needed for the AI trainers. So there are a lot of complex things and a lot of complex questions that really holds us back from local innovations, and locally introducing those AI models and training them with our own data for them to be used for our good.
Thank you, Liga. And then proceed with this question about the publicly available data. And we have quite a lot of data publicly available. Some of them are personal data, some of them are not personal data. From the perspective of the data protection, I would say everything which is not personal data, we do not care. And this may be others, like intellectual property rights, there could be other rights, but from the data perspective, we are taking care only on the personal data. And from the perspective of the personal data, some personal data are publicly available. We have a directive of the reuse of information, governmental sector shares quite a lot of data, possibly could share quite a lot of data with the companies. We have now in Europe Data Governance Act, who possibly with the omnibus will be compliant with the Data Act, and there will be one Data Act and not two of them, but still. So we say that governmental sector has to give the information to the private sector to create new services. And somehow we can see as well the benefit of the society, because the new services provided to the society makes the life of the society more comfortable. You know, we all have a ways who came, most of us maybe, leads here, and Google Maps, we also use them all the time. It's quite easier to live with this. But how do you think, and maybe there will be question, and Lig already answered on this, but for all others, how we should think about this publicly available data? This is accessible material, this is legally reusable material. Do you need some clear limits and safeguards on this? What do you have to take in account in using this publicly available data? And for example, if we're talking about this balancing of legitimate interest, does it, well, how to say it, I would say, does it that this data is publicly available data do not make it legitimacy tests more easier for the company, because it's not confidential, it's publicly already available. So when I'm testing the balancing of the data subject rights, and as well what he awaits of this, if it's publicly available in the internet, okay, you know that the internet now is affordable to the 5 billion people in the world. So that it makes it easier and better, and what do you think about how it could be in practice? And here I can start from the beginning. Julia. You're a lucky one.
Okay. I remember what Liga said previously, that maybe we need certain approach towards which data is the most sensitive and how to maybe some kind of categorize it, and what is the process of putting it into AI or sharing the data from the government institutions to the private sector to train AI. And this a bit resembles with the Digital Operational Resilience Act, the DORA, and the regulated sectors, which actually have this internal classification of data, which is personal, non-personal, information about code, information about how the processes are established, and etc., etc. Not only personal data about individuals, and there is certain levels of risk internally, how data is treated, and certain procedures and thresholds which cannot be crossed internally, and maybe the government and the institutions need to come together and think of this approach similarly, because there will be data of different sensitivity, which on the one hand can be very useful for commercial use. On the other hand, if we see the full spectrum, some data can be critical for state security, for maybe critical to avoid manipulation with the society, etc. So maybe this is state-level task to think about.
Gatis, maybe you. You said that publicly available data is a mess, but I remember your presentation. But okay, does it? How you look, for example, for this mess? If you collected from this mess some personal data, from your technologist and the implementer perspective, will you treat them a little bit different than, for example, data that you get from public health sector and some hospital?
Mm-hmm. So it's again a question if this publicly do this publicly all available data actually are fully correct. This is also a question. Yes, perhaps if we are having some kind of, let's say, authorized data, then definitely we can trust on that more. Yes, and based on that, if you're talking about publicly, it's not everything what's available publicly. This is true. Yes, and there could be actually also lot of mismatches. And based on, and actually at the given moment, it's also, if we are talking about all the hallucinations, it's also based on that we are getting some missed info data. Yes, so it's not confirmed that if it's written in the internet, this is true. Yeah, so we are knowing that there's plenty of info which is misleading, and based on that, this is again I'm returning. So that we need to look for and feed with the actually accurate data. Yes. But in the same time, if we are talking in Latvia we are having these say a lot of sources where we can get publicly available personal data. Yes, in this our open data GovLV. Yes, so this is also it's publicly available.
Okay. And Olivier, what is your thoughts about this legitimate interest balances with the publicly available data?
Perhaps first I want to pick up on one point that you made, that it's very important in my view to have some robust and clear frameworks for the data sharing. And I think this is also one of the objectives of some regulations that we have seen in recent years. You mentioned the Digital Governance Act, the Data Act, the European Health Data Space, etc. But I think this helps a lot to make sure that the data is not only available to few actors, but that it can be disseminated in a more reliable manner. Because we heard from you that, you know, when it's what I would call wild scraping of publicly available data, I mean, you don't have good quality data, and this leads to bias, etc. Now, I think what matters is indeed to look at the question of publicly available data. I would say it matters on two aspects: for legitimate interest assessment, as you mentioned, because it's part of, you know, the reasonable expectations of the data subject, and it matters also because it's one of the derogation to the prohibition to the processing of special categories of data under 9.2 of the GDPR. But I think one misunderstanding often, or one very bad practice, is to confuse accessibility and the qualification of publicly available data. Basically, it's out there in the internet, you can scrape it, you can have it. I think that's not the good way to go about it, and I think the Court of Justice was very clear on that aspect. I mean, there are many cases, but I can mention Meta versus Bundeskartellamt, where the Court of Justice clearly say that it's not because it's online, it's accessible, that the data subject wanted to make that data publicly available. It still requires, I think, in the word of the court, a clear affirmative act aimed at making the data accessible to the general public. So it's not because you visited a website that it's enough. It's not because you clicked, I don't know, on a like button or on a share button that you wanted to make the data public to everyone. And I think the court puts a lot of emphasis, especially if we speak about platforms, to the individual settings chosen by the users. And I think it's also a bit what the EDPB has been saying in its guidelines on the targeting of social media users. I think there you have some criteria to determine whether you fall within the publicly available data or not, and you know, it relates to the default setting of the platform, to the nature of the platform, to the accessibility of the page, visibility of the information, as to whether the information was published by the data subject or by a third party, because we all have information on, I don't know, social media that we didn't post, that were posted by third parties. And you know, it's a complicated exercise, but I think this is what matters. So it has to be a real assessment, contextual, evidence-based, and you cannot reason in a way that says, it's online, I want to, I don't know, boost innovation, and it's enough to use that data. I think this is not the good mindset. Yeah, I will leave it here.
Thank you. And Gunnar, what you can say about the publicly available data, using them for the training, and as well data which are not so publicly available but then accessible from the governmental sector?
Well, I think we have more questions than answers, and I see also this from the practice, and now we have this sandbox call open. Tomorrow ends the submission of first projects, and we already had a round of consultations, and what I see is that there is this uncertainty, there is a lot of questions from the developers, and I think the only option is to really go into those sandboxes and test those borders in controlled environment, and then we can make these best practices and be more literate about how to use the data correctly. Because of course we have different mindsets, but we have to do also this educational work and showing the best practices and educate our society how to think about data, how to approach, because there won't be like one clear formula we can use in every situation, but if we understand how to approach in principle level to those questions, then I think that in future that would be better decisions.
Yeah, please.
While we are on this page of sharing data from governmental institutions to private, I have a question to you, Ekaterina, because here we talk about legitimate interest as basis for processing, but as we know, the interpretation of GDPR goes that state institutions cannot have legitimate interest. What is Inspectorate's opinion? What is the basis how we can justify sharing this data, or is it always, should it be anonymous, or there are cases when personal data can be shared?
From perspective of the data protection, I would say, of course, anonymous data are preferred. Then you get rid of the GDPR, and then everything is okay. From perspective of the reality, I would understand that in many cases, companies would need the pseudonymous data at least, for example, to get these trainings. And for the governmental sector, I think we can use this public interest. And then this is dependent as well, this case-by-case basis. There could be the project which is in the public interest. And Liga mentioned in her presentation one of the projects. I know that there is a lot of the project in the governmental sector where the governmental sector by themselves initiates this. And in this case, I would say that they have a less problem than the private sector because they already have quite a lot of data. They can share them between themselves because they have some functions to make together. They have this public interest things. So it would be easier for them. What the problem is, and this is the problem what Liga as well mentioned in her presentation, that there was like 4 months talks about the data giving, or how to deal it with this. But from and I presume you are talking about the Citizens Register, for example, even Data Protection Authority, when we wanted to get access to the Citizen Registry, it took us a year and a half to get agreement and to get this data to us. So your 4 months is very easy, And I think that this is as well somehow that way. I asked, and maybe then I will ask you and maybe you, Liga or Gatis, you think and you have this from the practical point of view. I think that many of the persons are very afraid to give it, but this is as well for me what I see, that as for companies they're not so open, and then what we start to talk about is data subject rights, legitimate like legal basis, and we have legal basis, legitimate interest, but then you have to do the test, then you have to inform this data subject, and how we do it, or we do it in this, very small writing somewhere under the 100 pages, as Olivier mentioned in his presentation, or we announced it quite clear, and we said, yeah, we will do this and this, but you probably will have this and these benefits, and sometimes I feel like from the perspective of the Data Protection Authority that companies are afraid to be honest with the data subject. And maybe you have in practice answers why.
Yeah, if I may, I think it's, for me, it sounds a bit like the wind turbines, when they want to create this new wind farm, and then they have this public discussion, and then there are a lot of objections against, and for the companies, they are afraid of those objections. They are afraid of someone who will just come in and turn the table upside down just because they want to. They guard themselves, of course, yes, and therefore they put this in the 100th page, yes, so that it is there, they give the consent, but it's not just too open for everyone to see, so that the shouting doesn't begin, and then the competition doesn't begin, and so they are too afraid, I agree with that, and I think that there are cases when this discussion should be done, and it would make this whole process for the public to more understandable, created, like this question, but why do you need the public data, personal data? Why do you need Latvian data? Why cannot you use, I don't know, Lithuania or whatever, So
something out of the EU.
Yes, or for example, yeah. So yes, the companies should talk about it more, should explain why do we need this, why are we looking for it, and why are we trying to use it. And yes, I agree that as Gunnar said, that being afraid is not the good starting point, and it refers to both of the sides, both the public sector and the private sector. If we want to work with the data, if we want to create new AI agents and use this, we have to be open about it, be open about our why we are doing it. So yes, it would, I think, solve a lot of problems.
Yes, I want to just to add that I think it is important to clearly announce this purpose, what we are trying to achieve. And if we can explain to our clients, to the society, why are we building this tool or this solution, what social problem it solves, or how can it help the clients, then I think it's easier to explain why we need those data. And we understand ourselves, and we can explain also to other parties. And also from the conversations from the entrepreneurs, I also hear that there are businesses who can explain very clearly what problem they are trying to solve. They are trying to make better education tools so the education becomes more accessible, or some tools in healthcare. And then they also complain about competitors who also take those beautiful aims, but underneath they have very bad intentions, just to manipulate and maybe try to achieve something else. But if we are clear and open about these good purposes, then I think it's a good starting point how to communicate with our customers.
I wanted to add, actually, so there's, I don't know, maybe some 7-10 years ago, there was some another big, let's say, buzzword, big data. And on that moment, the companies was collecting like everything, what we are able to collect. We are just collecting for what, I don't know, maybe in the future it will be, somehow we will be able to use this. And maybe this is, again, so this is opposite side, when we are getting so too much data, which is actually not used, and we are able to get mess. And if we are talking about what the companies are afraid, I think the fines, yes, and this is true, and these fines are quite huge, and based on that, so they are really, let's say, don't willing to share, so better not to do than to do, yes. And it's actually it's the same if you're talking overall about the implementation AI in the companies, yes. So for I don't know, so most very frequent. So this question became to I don't know IT specialist, yes. And if this so it's some old school guy, for him it's again this is additional risk. I don't know so how this system works, and for me it's yes. Perhaps I understand it could help my business to let's say to grow and to be more efficient, but at the same time it also takes a huge risk, and based on that to not to take let's say responsibility, I will better so decline access, yes. And based on that, this is the way why we are not able to move. We are afraid for some fines, for some judgment.
But you see, talking about the fear and talking about the openness, if honestly we can come together now and we're starting like AI versus GDPR, but here I see that real point when GDPR and AI, what you're saying as well, comes together, because right to inform data subject was based on the possibility of understand to this person what will happen with my data. And all of you as well mentioned that this is very good for the company to be open to say this purpose, to say what we want to achieve. And this is the same rule on the data subject information. So we do not contradict to each other. So, and it would be as well good for the companies to be open, explain their purpose, and that's how you can inform data subject, and that's how you afterwards can avoid, for example, the same objections or some thoughts from data subject that my data is used unlawfully. Because I would say they also are afraid. They also are afraid how it will be. They do not want to be China, for example, or even sometimes nowadays USA as well.
It's actually answer is actually quite simple. We just need to agree on the safe principles, and these principles need to be set down by the government. So the way how we are perceiving the data, yes, and it's really at the moment I'm not sure do we are having like proper procedure how to do it, and if it could be first of all it could be available. Then the second, if we are also sharing some good examples, maybe it could so encourage also other companies to do it more. So maybe safe procedures is the answer.
Or some at least guidelines. Yeah.
Yes, exactly what I wanted to say, that maybe it is some kind of higher level task to come together, Ministry of Digital Development, the Center of AI and DPA, and just publicly somewhere say that we encourage development of AI in the public sector, but these are the rules, and then it is communicated to the business and to all the organizations, and we are allowed to do so, these are the rules, and there is less fear maybe in this situation.
Okay, but I always I always say that rules are known. There's a GDPR, but then I can understand that as well that there is a different interpretation of these rules. They are more stricter, less stricter, and that this becomes the gray area where maybe as well for these real makers and companies that there comes this fear from this gray sphere.
And for Latvia, I guess it's often a bit of overkill, like we protect too much. We've talked here about fear so much. It's like pure psychology. It's not data protection. So meaning that many institutions want to be too strict and are really like keeping and safeguarding too much, even in conditions when it's not so much necessary.
But I think that we talk about this because all the companies consist from the people. And then afterwards, all our, even AI, you mentioned it, it cannot work without the data, it cannot work without the people. And that's why it's our core thing that we have to talk about ourselves, what we are doing and what we can do as a representative of the governmental institutions, companies, data protection specialists and officers to make it better and to come to make these new technologies and data protection come together and be really friends?
It's actually also one question for you, maybe from that perspective. If we are having, let's say, okay, I'm not able to store your private data, but if I memorize it, what to do on that purpose? And for the human beings, it's quite understandable. Okay, you will forget for after some time, most probably, maybe not. So who knows? But on that case, if we are looking on AI, there are the same these principles. So AI have the memory, and this is that we are showing, and it actually memorizes. And then it's the question how you can forget if you are forgetting. Yes, if you don't know this anymore, let's say this private, then you are, let's say, different, let's say, human being or different AI this module. And this is question. So how to do we need to forget? It's how to answer? I don't know.
Okay, Olivier.
I mean, I have the impression that part of this discussion is also how to foster trust by individuals in very complicated developments that are emerging in relation to AI. And I think it was already mentioned, but I think one of the pillars to foster trust is really transparency, really to be able to explain in an easy manner, understandable manner to data subjects what you're doing and how you do it. And I think transparency is a good example, I think, where you need at the same time some pragmatism on the way you implement the legal rules, but also a sense of innovation from the practitioners in the field, to really invest time and resources to be able to explain in a good manner. And, you know, if you take, for instance, the GDPR, it's a bit easier if you have a direct relationship with the data subject. But most often, it's an indirect relationship. And, you know, I think you have the rules of Article 14 of the GDPR that you need to inform the data subject about several elements. And then you have some derogations as well. One of them is when the data subject already has the information. So I think here a potential good practice is actually to centralize this information to the first party. You know, to try to anticipate into the first place, that the first party has to provide the information in the first place before then you reuse it as a third party. I think this is the kind of, I would say, practice that may help to fit in the legal framework. And then, in the same vein, sometimes you don't have to give the information individually to the person when it's impossible or implies disproportionate efforts. I think here we need to look at, I don't know, the number of data subjects, the actual information you already have. Sometimes you don't have a lot. You cannot identify, you cannot contact the person to provide the information. So I think here there may be a need for guidance, but the point I want to make also is that there are other ways to inform also the data subject at a more general level, you know, using fact sheets, diagrams, public information, and even now under the AI Act for general purposes AI models, you also have additional layers. And for instance, there is now a template for information by the AI office to give information about the content of your AI model and how it was trained. You know, and this is the kind of information that helps to build the trust with the individuals.
But now I have a little bit, and that proceeds with the GATT, as was mentioned, and we talk quite a lot of the data subject information, right, of the information, and I would see here that we already find the ways how we can get rid of the fear, how we can put together GDPR, AI Act, and the real necessity for companies to get this data and to inform data subject. But then the right to be forgotten, right to erase data. And I have a very rebel question to Julia and Olivier, sorry for this, but do we really think that in the AI it's possible to implement right to erase? Because I'm a lawyer, you know, but what I have read about the AI, and I think GATT has just confirmed it, it learns. So it means it gets my data. So for example, if we want to create the model which help us to, now I think about it, but to create something that help people to get somewhere, and they use first of all it on the real people, how people really goes, which is roads, it's easier for them and etc. And then the tool is trained, the tool is created, and the tool just recognized that my, for example, pattern was to go on this road, and based on this recognition, the tool afterwards was propose some possible patterns to other people. But if I would say that, please forget this information for me, does it really can forget this information for me? Because he already knows that such a pattern exists. And that is for me why, of course, we have to create the models if they're really trained on the really personal data. So you have to remove them afterwards, and you cannot, for me, maybe use it on the same person. So you have to use it to the other systems and other persons. But does it really possible, like first maybe Gatis, you can say from technical, does it really possible to get out something from the model? I have read that there is some new possible token recognition that they will take 1 or 2 tokens out, and then they have this Dora memory, Dora fish memory, and then they will forget personal data. But maybe it's not like this.
I think so. This Dora memory, I actually first time here, really. But so technically it's like that. What I can say is definitely so. AI will not so forgot it. Yes, you're not able to erase it, but you are able to say to not to use or to not disclose, and this you can do. Yes, it's still so. The knowledge will be there, but if we are talking a bit deeper, then it's not guaranteed that for some other questions or similars. Let's say if you were talking about the navigation, yes, some finding the best route, and if this route is very, very complicated, I don't know. So Yekaterina found the best route, and then she thought, let's forget it. But on that moment, it still will be there in the memory, and if somebody else will ask, is maybe which is the fastest route, it will not show that this is your route, but this is the fastest route. It will be still there. So technically, it still will be in these memories. So perhaps maybe some new technologies or something can be, but technically they can say just not to use it.
Okay, and then the word to the data protection specialist then. What we can do, philosophically, can do with it, Olivier or Julia?
Okay, I guess for me, reading this EDPB suggestion to allow to use right to erasure irrespective of existing of the basis of the Article 17, this was exactly my question. Like, if everybody from the technical area tells that this is not possible to erase, why would EDPB suggest to erase? And I guess this is the room for more clarification, like how to perform and whether and by what means, as you mentioned, this right to erasure could be performed in AI. Also, AI agents is a hot topic and it's even more complicated. So there is a room for clarification.
Olivier?
I'm not sure I have an answer. And I think when we discussed about the panel...
This is the rebel questions, you know.
Exactly.
I do not know the answer by myself, so...
Yeah, and I think, again, we need to approach this question with pragmatism, also with, I would say, an open mind to the technical reality. I think that, you know, you can speak, for instance, about the right to object first, because it's slightly different, because there, of course, there is a right to object if you rely on legitimate interest, but the controller may still say that they have compelling and legitimate grounds to continue the processing. But I think what matters, for instance, in relation to the right to object is the timing, because I think it's easier to exercise the rights of the data subjects before the model is trained. And that's why I think the EDPB and EDPS, even recently, insisted on the timing, that you really need to allow the data subject, possibly without any condition, to object to the processing actually in a timely manner before the model is trained. And that's why also you need to leave some time between the collection of the data and the actual training of the model. to try to limit these cases. Now, it's also true that sometimes the model is trained and you still get a request. Then I think the challenge is to know whether you still have personal data in the model. I think that's a complicated technical question. But if you come to the conclusion that yes, there is still a likelihood of regurgitation of the personal data, well, then it's complicated, because if you think about the right to erasure, it may mean the retraining of the model. I understand this is an efficient technical solution, but wow, I mean, it's also very costly. It's also very expensive. It's a lot for the controllers that developed these AI models. I know, I mean, I don't think there is a uniform answer on the side of the EDPB, but I know that, for instance, national regulators, such as the French DPA, already issued some how-to sheets, and they showed openness to say that indeed in some cases it would not be the retraining the only answer to a request for erasure, but you may not delete the data, but you may put in place some output filters to avoid that the personal data is still disclosed when you use the model. So yeah, I'm not sure I have the answer, but I think yes, need for guidance, certainly.
As I mentioned by myself, I think the aim was maybe to start openly to talk about these problems. And we talked a lot about the fear. And I think that first, how you can get rid of the fear and go somewhere, you talk about your fears. And you talk about what the problems you have. And only then you can do something to resolve these problems. If everybody is sitting in their own corners and everybody thinking that, okay, it's better not to do, then nothing will be as well forced and given together.
Actually, I was sitting here and then I realized one question. Perhaps from this data perspective, you are looking on AI as the database, but it's not there's no data. This is knowledge, yes. And these are so. If I read a book, yes, I will give the book away. Book is the database, but the knowledge what I read, this is on AI, and we are not able to use the same principles what we are using on the database. We are not able to use on the knowledge, and these are this the difference. Then we need to think about how to not to use our knowledge, yes, or how to limit our knowledge. But for sure, it's quite hard if you know it's so, yes. To change the minds, it's complicated.
Yeah, and Gunnar?
Can I add, yes, listening to this discussion, I'm a lawyer by my education, so I was already started to think about some solutions. Maybe we can think about this and approach from the other perspective. As you already mentioned, AI is not a standard database. It's a new technology. It works different, and maybe it's the wrong point. Then we fight how to change this technology that it forgets the knowledge. Maybe we should approach what to do with it. Also as humans, we remember the information, but we have some legal limits how we can use it. If there is some state secret or some commercial information that is not public, then there are procedures or also reliability, responsibility if we misuse this. So maybe we have to look at it from the different perspective regarding AI. It's not like usual IT system.
Okay, and then maybe as our discussion comes to the end, from each of you, you can say some points on what should the organization do in practice to make the use of personal data and in-AI training more transparent, trustworthy, and as well legal from perspective of the GDPR, as we today talking on personal data?
Okay, there is a quite wide spectrum of organizations. There are some which are just starting using AI, and maybe for them it's even easier to have some control over this. But there are companies which have many AI tools, and currently many existing ICT services are enabling various AI assistants, AI features, AI agents within existing ICT tools. And this starts to go out of control. And these AI features come with additional terms and conditions. And sometimes these terms and conditions foresee that this AI capability is driven by a third party, which you don't know. And this is homework for many large organizations to have control and have some kind of, just like we have records of data processing, maybe have some registry internally and know what kind of AI you have in-house and where the data goes, what kind of data goes where, in which locations, in which directions, because all those new cool features comes with additional terms and additional risks.
Liga?
Yeah, I liked what you said about know your AI, I would say, because both the companies, both the public sector, or even in our personal lives, when we use AI, it is better to know who owns it, who does what with the information. Of course, we never know till the end, but before we put something in somewhere, before you put your finger in electricity contact, you think if it's really necessary, So I think, yes, in both ways, innovation is necessary and innovation is to be supported, but we have to think how we innovate, to be careful with the innovation as well, so to move forward, but also not blind-sighted, to look where we are walking and think and know our AI is what we are using.
We are living in AI Wild West right now. if we are talking, let's say, right now, if we are comparing these AI modules and engines what we are using, this is like we are getting like engine of Ferrari, yes, and trying to build a vehicle, and forgetting about brakes, about steering, about and based on it, for sure, most probably we will crash. And it's also, so previously there wasn't, let's say, speed limits in the Wild West so nobody was able to go, let's say, faster than 100 kilometers per hour. After, when we are able to adapt this let's say new technologies, we started to put some limits, and maybe this also that we need to start to think how we are able to put some, let's say, not to fully switch off, yes, but start to limit somehow, yes. And maybe on the first row you don't need to, let's say, start with Ferrari engine. Maybe you need to look for something, let's say, more realistic. If answering on your question, what the companies need to do or implement, I think this is first of all, let's say, make some, let's say, collect data and understand what you are collecting, make it on the proper order. This is first, so, and then understand for what kind of purpose you're using, and definitely some kind of documentation, which is also, let's say, you're able to show for some institutions. It could be, let's say, the first step, and then also, if you are building something for you, it's much easier to understand what kind of data you are having and what you are able to do with that.
It's like honey in my ears, because what you are saying is a data protection impact assessment, and that's where we always say to many companies, they have idea, and then you ask them, please make DPA, and then the next what I hear somewhere, data protection authority did not allow us to do it, and then like, no, we said you have to do DPIA. No, it's too hard. We do not know how to do it. We will not go to this. But what you mentioned is the same thing that DPIA prescribes company to do, to start with the life circle, to start with the purposes, to start with which data we need, how we can collect them, and then you can take, and as well, assessing all the risks. This is as well DPIA, but sorry, Olivia, now turn is yours.
I'm not sure I have much to add. I think someone said that innovation is necessary. And that's very true. Innovation is welcome, but innovation also has to be responsible. And to be responsible, I think the very wrong mindset would be to consider that it's technically feasible. You can harvest everything somewhere out there, so you just do it. No, I think that's the very wrong mindset. And I think what helps you is actually the law. Of course, I'm preaching now for data protection, but I think data protection tries to put some limits as to certain uses that cannot be done. And I think these are the red lines. This is what you need to think about. There are many tools for that, the principles, the DPIA you just mentioned. But I think, yeah, this is the backbone for trust. And I think if you implement the rules correctly, and if you take time, someone at the beginning said, yeah, the AI community is not, very immersed into the GDPR. I think that's an issue. That's a real issue. Because when they process personal data, the starting point is, what am I allowed to do? And I think if you implement this principle correctly, I think it helps you to know your data, to define why you process this data, and this leads, I think, to more trust. I know it's a bit general, but this is what matters, to really take the time to think about your project, to implement the principles, to sometimes struggle a bit. I can easily admit that. But I think this may lead also to good results. Perhaps one aspect we didn't mention so much, I think if you implement the principles well, it also allows you to have some human oversight and in a smart way. So not only to do some, stamps that you put on the review because there is a human behind each decision. That will never happen. But to take it seriously, to audit your system, to test it regularly, I think that helps a lot. And yeah.
Thank you, Gunnar.
Yes, I have two conclusions. One is, of course, AI is a new tool, new force that is given to us humans, and we have to figure out how to deal with it. And I think the best option is all the way to come together, discuss, try out, preferably in safe environments, test those borders and understand our lessons. And also transparency. I think transparency is medicine for different problems. So also I think in this case, transparency is one of the elements which can help build trust and move forward with innovations and safe innovations.
Thank you. And we have still some time, and maybe somebody from public has questions to the panel. I know Latvian public are very shy public, but still, I can give you the chance to ask the question. Maybe, we talked about the fear, to not be fear. Okay.
Hello, thank you very much for interesting presentations. I would like to reflect on two of them. So Julia mentioned that scraping of data is not prohibited, and Olivier mentioned that EDPS is working on new guidelines on scraping. So I was just thinking, does scraping has this negative connotation? Because you spoke quite a lot that, well, you can make the processing compliant by carrying out the legitimate interest assessment, the DPIA assessment, or that you can put into place some additional guidelines. So I was just wondering if with all these activities you can make the processing compliant and proper, or still it will remain scraping with this negative connotation? Thank you.
Thank you. So first, to clarify, it's not the EDPS that will issue guidelines on scraping, it's the EDPB. So all the national DPAs plus the EDPS. And it's in the work program. The guidelines are not finalized yet. I hope it will be the case in a few months, but so it's a bit difficult for me to say what the EDPB thinks. I can speak about myself. I think it's fair to say that there were some practices around scraping, entities going all over the internet, scraping everything, that are problematic from a GDPR perspective. Now, does it mean that any types of scraping is negative and is unlawful? I would not reach that conclusion. I think, there are some principles that you have to follow. Again, guidance hopefully will give some clarity. And yeah, I think it may be possible. If I may still, I think one very thorny issue is the processing of special categories of data. Because again, the principle is prohibition. Unless you have some derogation, the consent, that doesn't work really for scraping, or the publicly available data we discussed, it's not always, an affirmative action by the data subject. But I think an interesting question is that even when the controllers want to avoid the collection of special categories of data, they may still end up with collecting some, because it's a bit difficult to pre-screen or pre-scrape the internet to know whether you will scrape actually special categories of data. And I think here a question is, can you, for instance, draw analogy with the case law on the search engine? This is a case called GC, where the Court of Justice said that the search engine, if they delete immediately the page containing special categories of data upon indexation, it's okay. They don't need to find a derogation under 9.2. I'm not saying search engine and scraping are the same, but can we draw analogy from this reasoning and transpose it to scraping and special categories of data? Again, some national essays, DPA, already said it's possible. What will the EDPB say? We need to wait for it. And I'm speaking under the control of Ekaterina as well.
Thank you, Olivier. And now, if honestly, I would ask you, all the participants, from all the conferences, courses, we have something that I will take with me home. So what would be the statement, wish, or knowledge, or something else what you would take after this conversation and discussion, and you would like to participants to take with you? I can start by myself, so you have time to think, because it's not arranged questions. If honestly, I like the idea of guidelines, and I like the ideas of the cooperation. And we already, as a data protection authority, had a very, I would say, excellent cooperation with the Financial Association working on the AML and GDPR guidelines. So how we combine AML rules and GDPR rules on the practical point of view, when we were free, DPA, regulator of the banks, and Finance Association represented by the banks, so practitioners from one side of view, two regulators, and we created some guidelines. And that, for me, may be thought to take with me to create as well some guidelines. And I know my colleagues who are here hates me now, because it's like a new job assessment, but to maybe create as well some guidelines on the national level, how we can combine these data protection rules, AI rules, at least maybe to start to explain people so they would not be so afraid, and they would know this path to go if they want to do something. But then the floor is yours. Today you're unlucky. You will be or maybe somebody other brave who can take the floor first.
No, I'm not that unlucky. But I actually really like your idea about the guidelines, because in different countries where my organization is represented, it is already happening. There are some borderline gray zone cases which potentially may fall under high risk, and then already financial associations together with DPAs, they are discussing whether or not and how to interpret the AI Act, etc. Very good idea. But for me personally, I didn't know about that EDPB is working on the scraping guidelines. Thank you for this knowledge. This is very valuable. And another completely different thing, I heard so many times today that private sector is cooperating with government institutions, and this is very nice realization as a citizen that innovation and government is going hand in hand, and it is a good feeling that AI is not only speeding up in private sector but also in public.
For me, I guess it will be that before this conference, I was talking to those who are AI trainers, so to say, and most of them said, no, we don't do personal data because it's just too hard, and we stay away from that. And I think that the confidence that I got today, that you are also open to give this data on legal grounds, and if when it is really really necessary and objective to provide it. So I think for me it will be that I can ensure those companies and help them understand that actually it's not a closed door, you know, maybe just knock on the door and it will open, you know, so that we can help support this cooperation even more, that it happens.
You actually took my words, but I want to also admit that definitely, so the confidence is what I will take with me, courage and the context. Most probably I will reach out afterwards. Yes, and actually it's really actually encouraging for as you mentioned, not too afraid of the personal data, but let's try to do it on the proper way. Yes, and maybe so that you are open to do it. This is what I will take this chance with me. Thanks.
On my side, I will pick up the point on guidelines because I'm very much involved in the creation of guidelines and the work at the EDPB in particular. And I think, again, the importance of these moments where you can engage with practitioners and I would say with persons also outside your bubble, also outside the data protection community. And this is very, very important. And so thanks for setting that up. And I think it's not only about guidelines as well. You also have other ways to have this conversation, to understand better the needs, so you can give meaningful replies, so you can understand better the challenges. And I think you made the point that sandboxes, for instance, is a very promising tool. And yeah, this is my takeaway.
So I will go away with the encouragement to work on the sandbox even more harder. So this is a really practical way how we can test those borders and understand this cooperation algorithms. And yes, also regarding these guidelines, I fully agree that this is work between different stakeholders, because it won't be like the government will issue some theoretical guidelines. For example, currently AI Center is starting cooperation with HR Association, so we will try to develop together with HR specialists some guidelines how to use AI in HR processes. So they are practitioners, they understand their processes, and other experts can involve and explain risks, legal requirements, and then hopefully something good will come out and practical. So thank you.
Thank you very much. And thank you really for the participation, for the sharing your opinion quite openly and honestly, and answering as well on the rebel and not maybe so certain questions. And for me maybe as well, what I would say when the car was created, I presume that many people said that this is a very, very dangerous thing. And this is a dangerous thing. It kills us, like people, every day. But we still does not want to get back to the horses, because also horses kills. So I think that what we have to do and how we have to think about AI development and personal data protection, this is the car, new car that we created by ourselves, but this car cannot go without the rules. And GDPR would give us these rules and area of maneuvers when we can drive the car safely and not hurting other people and ourselves as well. So I hope that after this conversation and discussion we have others to create better understanding on the AI and GDPR and make them friends. Thank you very much, and now well-deserved lunch. And for those who are online, you as well have lunch, but by your own. Thank you very much.
So, good afternoon, everybody. I'm Lauris Lenebergs, and I have the pleasure to moderating this panel this wonderful afternoon. I hope you all had a nice dinner, and I hope you will be energized by the great discussion you will hear on quantum computing. So, it was intended that we will have a formula on the screen, which is like x plus y is bigger than z. But the formula is not the most important part here. The most important part here is the numbers behind the formula. And I will have a dream team that will help me find the numbers behind this formula. And so I ask you to welcome them on the stage here. So the first is Professor Andris Ambainis, and he's a head of Quantum Computer Science Center. Then we have a researcher from Institute of Mathematics and Computer Science from Latvian University, Krišjānis Petručēna. Then we have a IBM Quantum Ambassador, Piotr Benke. And we have also legal perspective represented, so Data Protection Officer Arnis Puksts. And attorney at law, Juris Balodis Bolušs. Guys, clap harder. Get the blood flowing. Yes, that's what I'm talking about. So, can I get a formula on screen? Yes, this one. So, I must confess that I'm quantum computing noob. I don't really understand physics, and I have a law background. But I did my due diligence, and I read a lot of stuff in internet. And I found this formula, which is Mosca's theorem, or sometimes referred to as Mosca's inequality. And what does it mean? It's not maths, it's actually risk management. So X is the time our data must remain secure. Y is the time required to migrate our system or data to quantum safe systems. So to introduce post-quantum cryptography. And Z is the time until quantum computers can break current cryptography. So if X plus Y is greater than Z, we might have a problem because our data might not be secure anymore. So, and my visage for this panel was kind of to help everybody find the numbers behind those letters. How to calculate X, how long could be Y, and how close are we to Z. So what we today are going to do, we will have a short round of presentations from our Dream Team speakers. We will get an explanation what actually is quantum computing. Then we will look at what post-quantum cryptography is. We will assess technological progress and quantum advantage. And finally, we will discuss real-world risks, such as harvest now, decrypt later, and what can be done today. With that, I would give floor to my first speaker, Andris Ambainis, about quantum computing as such. Andris, please, the floor is yours.
So I will do a brief introduction to quantum computing today. The basic idea of quantum computing is that we combine quantum physics with computing. So quantum physics is the part of physics that deals with laws of nature on the scale of atoms or individual particles. The laws of physics there change compared to what we see in everyday life. The laws of physics are somewhat different. And quantum computing studies how we can make use of that to do some things with computer much faster. And these things include in breaking some of the most commonly used encryption systems. So this is what quantum computers look like. There are several quantum computing technologies. There are superconductors, there are ion traps, there are neutral atoms. There is a lot of ways how to do quantum computing. They all make use of laws of quantum physics in very different ways. Some of these devices need to be cooled to extremely low temperatures. Other devices work in room temperature. Some devices might use electrons, some might use atoms, some might use photons, some might use some other particles. They all implement the same laws of computing, and these laws of computing are more powerful than the ones in our normal computer. And the thing why quantum computing is more powerful is that quantum systems can have a huge number of states. So if we think of a system consisting of just 30 particles following laws of quantum mechanics, then the number of possible quantum states is 2 to the power 30, which is 1 billion. And if we go up to 100 particles, the number of possible states of a quantum system goes up to 2 to the power 100, which is 1 with 30 zeros. So a quantum system can have an enormous number of states, and this enormous number of states can be used to compute things more efficiently. So this is what is called quantum parallelism. If we had a quantum computer with just 20 particles, we could use these 20 particles to do 1 million computations at the same time by computing at every quantum state at the same time. So one way how you could think of quantum computation is that it's like parallel computation, but you don't need many computers. You can compute on the same 20 or 30 or 100 particles and use the fact that these particles together have an enormous number of quantum states that we can use. And then there is a second phenomenon called quantum interference, through which one can combine results of all of those computations and get a result that depends on all the things that this quantum system has computed simultaneously. And quantum computers have several applications. They can model physics and chemistry more efficiently. They can break encryption schemes, such as RSA and all the schemes that are similar to RSA. Quantum computers provide advantage for tasks where you have to search for the best solution among a number of possible solutions. So you can think of some difficult scheduling problems where you have to examine a lot of different schedules and to find the best schedule. They might be good for machine learning, and they might be good for many other things. And regarding data encryption, the way how secret communication works today is that at first our computers exchange secret key, and then they use this secret key to encrypt the data. And what is in danger is this key exchange step. It is typically based on one of a handful schemes, and all these schemes use one kind of mathematics. So these are schemes like RSA, Diffie-Hellman, El-Gamal, whatever. There's about 5 of them. They are all based on the same mathematical principles. And these mathematical principles somehow are such that quantum interference breaks in every one of these schemes. So, well, like in technical terms, they are based on things like hardness of factoring or discrete logarithm, and these problems can be solved very efficiently by a quantum computer. And regarding practical quantum computing, I expect we'll hear more from the representative of IBM, but currently we are in what is called NISQ era, which is near-term, which is noisy intermediate scale quantum. This means that we have quantum computers of a somewhat moderate scale, and these quantum computers are still noisy. They make roughly 1 error per 100 or 1,000 steps of computation. And at the same time, these devices are already beyond what can be modeled on a conventional supercomputer. So they have achieved what is called quantum supremacy. They are complex enough that one can no longer model them on a conventional computer, even the most powerful one. And the next step is building more and more powerful quantum computers. There are different predictions for it. So the prediction when we would have a quantum computer capable of breaking the encryption that we use, the predictions range between 2035 and 2060. There are ambitious industry roadmaps that say that we might have such a quantum computer in 10 years. There are expert observers who think that it's more like 35 years. We don't know, but the field is definitely progressing. We have much better quantum computing technology than we had 10 years. There's much more money being invested in the field. And the field will continue to progress in the next 10 years as well. And that's all from me. Thanks for listening.
Well, thank you for the excellent and informative presentation. Could you please take your seat, because I have to introduce a person who has joined our panel as well. He's not some random guy from the street. He's a researcher from Institute of Mathematics and Computer Science as well. And he is Sergei Kozlovich. So, clap. And now he, with his colleague Krišjānis, will give a presentation on post-quantum cryptography. The floor is yours.
Okay, so me and my colleague, we are researchers, and we work at the institute, which is the first place in Latvia where the first internet connection was established in 1992, and also the first quantum link was established there. But the history began sometime before that. Yes, it started in the year 1800, when Alessandro Volta invented the first battery, and then the classical computers appeared, and exactly 100 years after that, Max Planck introduced his famous Planck constant, and the quantum theory was born, and now we have also quantum computers. These are like two parallel histories, and now we already have some quantum processors like Google Willow, Microsoft Majorana. They can be used for material science, for drug discovery, for bioinformatics, for optimization problem solving. Currently, these processors have very little memory, but in the future, we hope, as Professor Ambeni said, that maybe in 35 years, we will have much more memory, and these processors can help us to solve these problems. But also, this is like a double-edged sword, because these processors can also break cryptography.
We have all heard about the quantum threat, the apocalypse that's coming. In our daily lives, one of the prominent use cases of computers is browsing the web. To browse the web, we use the EDPS protocol. It secures our connections, but it wasn't always the case that our connection was secure. In the 1970s, when the internet was born, the data was unencrypted. Anyone could listen. EDPS, which we now use, is based on TLS, the first phase of which is the handshake. To illustrate the role of the handshake, let's introduce our two actors, Alice and Bob. Alice wants to send Bob a secret message. She has never met Bob before in her life, but she's smart. She can construct a chest, which only she can open with her secret key, send the chest in an open state to Bob. The Bob can then generate a secret piece of information, which is called the key, which can later be used for encryption, put a copy of it in the chest, and send it to Alice. Only Alice can open it. This solves the key exchange problem, and without dwelling too much into the mathematical details, this solves the key exchange problem before we had quantum computers. But there's another problem, is that Alice doesn't know that the chest came from Bob, and Bob doesn't know that the chest came from Alice. So there also has to be digital signatures, so Bob can put his certificate and sign the key prior to sending the chest to Alice.
Okay, and here we can see this process of establishing a key. This is the first part. And actually, this is the most bleedy part of the quantum computing, since this is a double-edged sword. So in the first part, there is a key exchange process and also the authentication process, that Alice can be sure that she is talking to Bob and vice versa. And now, after the key has been established, then they can use this key to encrypt the communication, and usually an AES cipher is used. It is a bit affected by quantum computers, but it is considered still quantum safe if we use a quite large key, for example, 256 bits. So for the quantum computer, this key looks like a 128-bit key. So it is a problem, but not that big. And the most difficult problem is this red part, where we have to exchange, to change these algorithms to some quantum safe algorithms. Yes.
What can we do about it? Our personal data is leaving our own computers, traversing the network, and there may be some eavesdropper. So first of all, let's address that quantum computers are not universally much faster. It just so happens that the efficient ciphers, which we chose 30 years ago, are prone to quantum computers. And there's a whole subset of asymmetric cryptography, meaning there's a public key and a secret key, and a chest that can only be opened with secret key, that we consider to be secure against quantum computers. And in 2016, National Institute of Standardization of Technology of USA launched a PQC competition. It was a global effort, and 3 algorithms were standardized 3 years ago. But unfortunately, we're still not 100% sure. Maybe there's something we didn't think about. And the finalist Rainbow, which was a digital signature algorithm, was broken after 17 years, leading to an adversary to fake a signature. And if we take a step back, I said Alice has never met Bob in her life. Maybe if she just carried the symmetric key on a flash drive to Bob, that would also be sufficient. So there's an informal term called sneakernet, which is the transfer of media by carrying USB flash drives, hard disks in suitcases and trucks. And actually, we previously saw TLS, and there's a variant of TLS that doesn't assume that, that both parties already don't share a secret key. So, and if we make the keys long enough, we can actually prove that no matter the size of the computer, no matter its type, it can be the size of the universe, and given infinite time, it will never be decrypted. But sometimes it's not practical to carry a suitcase. This is where quantum key distribution comes in. It's not widely adopted because of its cost. You need special infrastructure, special optical cables, and in the canonical protocol BB84, polarized photons are sent one by one. This also requires a bit of a mindset change, because instead of encrypting, we detect eavesdropping. If someone were to attempt to eavesdrop the connection, we will, with very high probability, detect it. And it's provably secure due to how quantum physics works, the no cloning theorem, and so on, and we believe it to be true.
Okay, so we have two solutions. One is physics-based, quantum key distribution, QKD, and another is mathematics-based, post-quantum cryptography, or PQC. And here you can see properties of both solutions, and as you can probably notice that the strengths of one solution match the weaknesses of the other, and vice versa. So the idea is to combine the best from both worlds. And that is exactly what we do at our institute, and many other researchers do the same. So they argue that we need both technologies.
You can also see a wide adoption of post-quantum cryptography in the industry. Major browsers, messaging apps, programming languages already implement the hybrid key exchange, which incorporates the new post-quantum cryptography algorithms with the old classical time-tested ones. If we go into inspect element of a browser in the security tab, we can actually see that the module lattice chem algorithm is actually being used, and it is now enabled by default. And at our institute, we have gathered, accumulated both positive and negative experience, and in a project co-funded by the European Union and Latvian state, we got our hands on a real quantum key distribution hardware, and with our partners, Electronic Communication Office of Latvia, we actually integrated quantum key distribution into 5G networks, such that the request from mobile phones would get routed in the largest portion of the path through a channel that's secured by quantum key distribution.
And here is a picture of what we have done. So in the bottom you can see this very secure backbone. So you can look at it as an Ethernet cable, a wire, which is very, very secure and can transmit gigabits of data through encryptors. But those two encryptors near the cloud in the middle, they take keys from quantum devices. So this blue rectangle is very, very secure. And we can provide access to this very secure backbone in different ways, for example, as VASES or Electronic Communication Office did in the previous slide. And here we can provide also access through VPN. But of course, we don't need traditional VPN. We want quantum safe VPN. And there are a lot of challenges because post-quantum key exchange is already implemented there, but post-quantum signatures are not. And so it is difficult to configure, but we know how to do it. So if you need this post-quantum VPN, you can go to us and we tell us how to do that correctly. And also we have developed this interesting library for integrating any quantum key into the TLS protocol, exactly into that protocol which works when you open some web page. So we can embed any quantum key there into existing TLS connection. And also we can use post-quantum certificates. And since not everything has been standardized yet, for example, identifiers are not standardized, and there are different browsers yet don't implement these post-quantum signatures, we can implement it by our own. So we have this quantum agility capability. So we can use new emerging algorithms and technologies and check them using the real TLS connection. And in the LatQN project, we have developed this triangle topology of 3 quantum links, and they have been interconnected via trusted nodes. And also we checked this topology by cutting the wire. So if you cut one quantum wire, all other nodes still have to be able to communicate. So, and we did it. So it's not a trivial problem, because you need to connect physically to 3 quantum links and to exchange keys between them. But we know how to do that.
Post-quantum cryptography requires a secure foundation. Whitfield Diffie said, if you can have random numbers, you can have a private conversation. And to have truly random numbers means to use a quantum random number generator. And this, in the picture above, you can see a real commercial device that you can plug into your computer. And but if you do it, nothing really happens. The operating system doesn't know how to make use of it, nor do the software. And at our institute, because Linux is open source and OpenSSL cryptographic library is open source, we modify the software to make use of the external hardware random number generator.
And we would like also to provide quantum key distribution and all these quantum technologies to a wide class of devices, not only to servers, but also to laptops, IoT devices, your cell phones. So we have developed an algorithm, a protocol, which can bring these quantum keys to your devices without actually having these quantum boxes. Because quantum boxes are heavy, they need a lot of energy, they actually are fridges, and they are very expensive. But this protocol can be used for free to any consumer device. And now Christian will tell something about our future prospects.
Right now, at our institute, we are working in a common European interest project to develop cloud access architecture, a quantum-safe way to access the cloud, to secure the interconnect between data centers, to secure backups. And in another project, LatLit cross-border connection, we try to connect to the greater European quantum network. So there's a project EuroQCI, European Quantum Communication Infrastructure, which aims to connect all European Union countries by these quantum key distribution links.
And this is only the beginning, because as you see from this diagram, we are at the ground floor, the quantum key distribution floor. But our goal is to develop the real quantum internet, where you can send qubits, quantum bits, using quantum entanglement and entanglement swapping and quantum teleportation. And we also are looking for satellite-based communication, because terrestrial quantum links have limits on the length. But if we have satellites like the Eagle-1 satellite, which will be hopefully launched this year, especially designed for quantum key distribution, then we can cover more distances and more countries using quantum key distribution. And that's all. Thank you.
Well, harder. It was really, really interesting, at least for me. And thank you for the insights on post-quantum cryptography and for what's happening in Latvia currently. And now I will give the floor to representative of one of the really big global players on quantum computing, quantum ambassador from IBM, Piotr. Please, the floor is yours.
Good afternoon. Thank you for the invitation and congratulations on your anniversary. Yeah, at the beginning we heard about how quantum computing is computes and what are the challenges related to this. I am going to present you how we as IBM implement quantum computers and how we secure currently the existing systems using the standards of post-quantum cryptography. As you can see, our mission is to bring the useful computer to the world. And in fact, we develop the biggest quantum computers at the moment possible. And since 2016, we offer these quantum computers free of charge to the community worldwide. So everybody who wants to play a little bit with quantum computers can try this. And of course, there are some limitations. Yeah, for regular users, like people from the street, you can consume 10 minutes per hour, per month, free of charge. So it's sufficient to start understand and start to play with quantum computers. But we also, from the very beginning, noticed that it is also huge risk. If we will be able to decrypt communication in the internet, if we will be able to decrypt communication between the terminal and credit card, or over IoT devices, that means that we will change the way how the data will be processed. So this is why we spend lots of efforts and time developing also post-quantum cryptography. And what is this about? Yeah, we are proud that we have very supercomputers, very strong, which can solve lots of impressive things. But in fact, we are approaching to the wall, yeah, in developing these classical computers, because we cannot reduce the number of atoms which are dedicated for transistor in CPU to less than 1 atom. So we cannot shrink the architecture of processors. The second thing is that some problems are by definition not for classical computers. That is what as it was mentioned by Professor. There are some spaces where we can see huge advantage using quantum computers like simulation, optimization, machine learning. And we are really focusing on this. Quantum computer will not replace classical computer. It will be a hybrid solution. And at the moment, we have such a hybrid solution. And at the beginning of this month, we also announced the reference architecture for quantum-centric data center. And this is the future of computing per se. But there is also a huge space where even quantum computer cannot help us. And that's good, because the problems from this space are used to protect data which can be processed by quantum computers and by classical computers. When we are looking where we can find the application of quantum computers, at the moment we work with many big players on the market. And we are trying to find more efficient way to produce fertilizers in the agriculture. We are trying to find a better way how to provide the algorithm and provide better logistics for food, to reduce the waste of food. There are lots of multi-factors problems which cannot be solved in a reasonable time by classical computers. And this is the excellent space for quantum computers. Of course, chemical industry. Lots of things. For example, ExxonMobil, we work on the new way how to process the ore, oil ore, to be more efficient. financial sector. I think this is the best prepared sector for this new era of quantum. Why? Because everybody wants to better predict the prices of, for example, bonds. Everybody wants to have better portfolio of optimization, just to be sure that they spend less money working on a new financial product. And pharmacy. We have lots of collaboration with many partners worldwide, including, for example, Moderna, and working on the RNA structures using quantum computers. As you can see, majority of these examples just are related to new materials, but also the optimization. For example, in energy and utilities, where we have lots of new renewable sources, we need to optimize the grid, how to leverage the grid, how to leverage the energy storage to have it more efficient and to avoid blackout. This is one of the examples. In the logistics and transportation, with Boeing, we are working on new materials, multi-layer materials, which are more resistant and lighter, reducing the consumption of energy during the flight. So these are the examples where we are trying to find the proper applications. And even if the quantum computer at the moment is as Professor mentioned, this is a noisy quantum computer, we already can find some ways where we see lots of benefits having the computer in the near future, which will be more powerful than this one we have today. As you can see, all the sectors are trying to apply these quantum computers, because there are many problems which were so far not even, the companies were thinking about how to solve it, because it was not possible by definition. It took too many years, days to compute some of these elements. Let's imagine that during the simulation, sometimes when we are discovering new materials, we spend months sometimes to do the simulations. When it comes to quantum computers, there is a promise to complete the simulations within 1 or 2 days, for example. So there are lots of good examples. Let's imagine the very simple molecule coffee. At the moment, even the supercomputer cannot simulate fully all the energy stages of this simple molecule. This is a very small molecule. And to do this on a classical computer, you need to have number of bits equal to 10 to 48 power bits. So it's roughly, this number is 10% of atoms on the Earth. But when you are looking at the quantum computing, you just need 160 qubits to analyze all the energy states of this molecule. And what we are doing at the moment. So at the moment, last year we announced the quantum-centric data center. So actually we've built this data center in Poughkeepsie. And we demonstrated that hybrid solution, quantum plus HPC solution, works efficiently. This year is the year of quantum advantage. So you see that in the news that from time to time some interesting news pops up, where we see, okay, something was computed, calculated using quantum computer, which was not possible to do this without quantum computer. Because we have these noisy computers, we need to create the error-corrected quantum computer. And this is the goal for next 2-3 years from now. And we have some ideas how to do this. The roadmap is pretty detailed. It's difficult to read this here. But if you have this material from this conference, I suggest just to spend some time on looking at this. It seems that the quantum computer with 2000 logical qubits will be available in 2033 or slightly beyond. So this is in line with what was presented before, that this usable computer which can be a real threat for RSA algorithm will be in 8-10 years from now. At the moment, we work with many partners and universities, and we installed quantum computers with 157 qubits in Japan, in Canada, in the US, in Germany, in Spain, and recent cell was in Romania. So these computers are highly efficient for education, but they also allow the researchers to play with some new ideas and apply these ideas to these quantum machines. When you look what is possible, what is not possible, at the moment we are at the very beginning. We are in the phase of quantum utility. So we have machine which is useful at the moment, and they can do some tasks which quantum classical computer can do as well. But starting from this year, I think that we will see more and more news that quantum computer did something which was not possible before. And we are going in two directions. We are going to extend the number of qubits. So that means that the bigger number of states can be computed in the same time. But also we are working on how many gates, the specific type of specific element which is used during the programming quantum computer, and we are going to increase the number of these gates. So we are not working only on hardware. We work also on software. We work also on programming libraries for developers, and we work with the business and academias on use cases and applications. So because at the moment there is the fight and a huge race for algorithms. There are not so many algorithms for quantum computers still, and we need to, and this is a great opportunity for all the countries. Even if they are not advanced in building quantum computers, there is a huge chance and opportunity for countries to invent and develop algorithms for quantum computers. As you can see on this chart, the real risk for cryptography will come around 2033 and beyond. And what I mentioned, I mentioned that we've built already HPC quantum-centric data center. This is the picture of this is the picture of the future machine. But we've integrated classical GPUs, CPUs, and QPUs, so quantum processing units, in one environment. So at the moment, we already created the library for software developers where they don't need to really understand where they send the data. So it is done automatically by the algorithm, by the system which supports these libraries. Of course, developers can control quantum states as well through this popular language like Python, C at the moment. And by the way, thanks to this combination, as I mentioned, this month we announced the reference architecture, we opened this idea to the world. Yeah? So everybody who has huge computing center can play and apply this architecture as well. And based on this, there are new discoveries, mainly in chemistry and in pharmacy, the industry, where we see that they are leveraging this infrastructure, hybrid infrastructure, not only cloud, not only quantum computing. And it's visible that this year, probably this line today should be slightly shifted to the beginning of this intersection of these two lines. And it indicates that we are really on the edge of new era of quantum computers and the possibilities and opportunities. Now we understand how to apply quantum computers in some spaces. So there are more funds, more energy focused on these areas. And a great example is, is that we have a nice discovery of new molecules which never been discovered before by classical computer. It was not possible. With Cleveland Clinic, who owns quantum computer, they decided to buy it as quickly as possible to develop the team skilled in quantum computing. They are really focused on building the new way how to simulate proteins, to accelerate the drug discovery. And do you know what is the average cost of building new drug on the market and introducing? 2 billion. And this is a really fight for time, because when you shrink the time, you provide lots of simulations. You can provide evidences that some of the simulations are the proper one. Thanks to this, you can reduce the price of this drug discovery, and also you can accelerate the introduction to the market. And of course, we have some challenges. As it was mentioned, quantum computer is quite good in factoring. I mean, it can discover, for example, these big prime numbers and can quite easily handle with this. The good news is when you are using symmetric cryptography, like AES, you don't need to be worried so much, because the speed up for this cryptography is quadratic. So that means if somebody spends millions of years calculating breaking the key, now using quantum computer, if the quantum computer will have a sufficient power, it will spend 10,000 years. So still long time. But in case of asymmetric encryption, then we have a Shor algorithm, which has exponential efficiency. So that means that we can decrypt something which is encrypted, not in millions of years, but in hours. And this is the challenge, and the challenge which needs to be addressed now. Even if we have quantum computers useful, the perspective is quite long from today, it's not so long. Let's imagine that you need to replace all the cryptographic policy in your organization. You need to verify all the cryptographic lines where the applications are using cryptography. For this year, for example, thanks to AI, probably we will have additional 1 billion applications. And they will use old cryptography if they will not introduce the new one. So that means that they will be vulnerable for this kind of technology in the near future. The most common practice at the moment is harvest now, decrypt later. The bad players on the market, they are collecting data, regardless if they are encrypted or not. And they will wait for the quantum computer who can help to decrypt this. And when you say, okay, it's 7 years, but I don't need to mention to this audience that 7, 10, 15 years, it's a problem if we will reveal the data in some cases. When we are talking about national registries, when we are talking about healthcare data, this data needs to be protected as much as possible. And we have approach to this, so we've created some kind of approach how to help organizations to create the strategy for being crypto agile. So that means the crypto agility is mandatory thing at the moment for all the organizations who think seriously about cryptography. So your organization needs to easily switch from one algorithm to another. I mean, easy not means from one day to another, but from 1 year to another. Because this is a long process, as I mentioned, there are lots of cryptographic elements in many elements of the infrastructure in your IT systems. And it needs to be ensured, and you need to be ensured that you identify these elements, you replace it with the proper cryptography, you ensure that your supply chain, your providers of applications do the same. You need to be ensured that you have a proper management, so you control which kind of cryptography is your environment. And you need to ensure also that your infrastructure is, at least today, ready for cryptographic, post-quantum cryptography. As I mentioned, IBM worked on this standards mentioned in the previous presentation. And we work on 3 out of 4 standards, which were accepted as a standards by the NIST organization. This is Crystal Dilithium, Falcon, and Sphinx. But we've noticed that the efficiency of these encryptions is not as good. So from the number of bits needed to ensure that the encryption is in place. So we are working on additional 3, which reduce significantly the size of the additional bits which needs to be done, needs to be added to the data to ensure that we have a proper encryption. It is useful for internet connection. It is also useful for IoT solutions because shorter keys means less energy as well in the communication. And thanks to this, we can apply this cryptography also for the devices which are not so well secured at the moment. And we, from the very beginning, we implemented this solution in our hardware for our clients, but we also help clients to providing software solutions to analyze what is in their environments, what kind of cryptography is in place, where in the code you have this kind of cryptography, but also we can provide the solution where non-quantum safe and quantum safe cryptography can exist within one solution, providing some kind of proxy remediation solution. And world is not sleeping. Now everybody has noticed that this is a huge potential, huge opportunity, but also huge threat. And 18 European Union members just creating some kind of recommendations, but not only from your perspective, also industry-focused organizations are creating some kind of recommendations related to cryptography. It was the recommendation in the US that all the public administration, which they are doing public procurement procedure, they are purchasing infrastructure, they need to have the infrastructure already with quantum-safe cryptography. What good is, it was not mentioned here during the presentations, post-quantum cryptography does not require quantum machines. It is the cryptography which is difficult for quantum computer as for classical computer, but it does not require quantum technology to implement this. Thank you very much.
Well, thank you for insights and for excellent summary about the technical aspects of quantum computing. And now we have come to the legal perspective, and I will ask attorney at law, Joris, to speak about the legal perspective on data protection on quantum computing, not data protection, sorry.
Dear Lauris, hello dear audience. Sorry, I'm a lawyer, it wouldn't be fun, but anyway, I should do it. So as Lauris told, my name is Juris Balots-Bolušs. I'm attorney at law and a doctoral candidate focusing on the intersection of technology and law. And that's probably the reason why I'm here. Not just that I'm an attorney, but my interest and my focus is on technology and law. Today I would like to address a question, how prepared is the legal framework in Latvia for the challenges of emerging quantum technologies, and a few other related minor questions. So, quantum technologies are no longer purely theoretical. Some are already embedded in everyday life. For example, MRI in medicine relies on quantum mechanical principles. However, lots is in the future, and emerging technologies promise further advances in timekeeping, imaging, secure communication, and computational power. And what I wanted to stress is that we heard today a lot about quantum computing, but there is a lot more behind the technology. And so it's the legal challenges is not just only about quantum computing. So anyway, with all the goods, there are also some risks, and the technology introduces new uncertainties, and as I said, risks. From the perspective of personal data, two developments are particularly important in my view. First, quantum technologies expand the scope of available personal data through new imaging technologies. Second, and more critically, they create new vulnerabilities in existing security systems. And that's what we heard today. So, and that's a key example for the latter is this quantum computing and its potential to break current cryptographic systems. This gives rise to the harvest now and decrypt later problem, where encrypted data intercepted today may be stored and decrypted in future. In plain words, this means that data secured today may not remain secure in the future. And that's what we need to think about. Turning to the legal framework. Several policy documents in Latvia, such as National Security Strategy and Latvia's Cybersecurity Strategy, refer to quantum technologies. However, these mentions are brief and lack detail. They highlight the need for secure communications, readiness for quantum-related cybersecurity challenges, possible use of quantum technologies in critical data processing, but go no further than this. Latvian law, in the strict sense, shows a similarly limited focus on the issue. Only one act, legal act, refers directly to quantum technologies in a meaningful way. It's a national security law. Beyond that, beyond this one legal act, our legal system relies on the principle of technological neutrality. Laws are drafted in broad terms so that they remain applicable despite technological change. This can be seen in cybersecurity and electronic communications regulations, the same as the GDPR, the subject that's more closer to you. At first glance, this suggests that existing frameworks may already accommodate quantum technologies because law is neutral. However, neutrality also creates uncertainty. Broad legal concepts leave room for interpretation and raise questions about what actually they require, and even whether the legislator intended them to cover emerging technologies at all. I could mention, for example, example of text and data mining. It is considered to be technological neutral, but what does it comprise exactly, and does it comprise AI training? It's a subject hugely debated within copyright field. So having technologically neutral concepts doesn't always mean that we are in a safe territory or that everything is clear for everybody. So that's about a small summary about Latvia, but we should bear in mind that Latvia's legal system also operates within a broader context of European Union law. And at the EU level, a gradual shift toward addressing quantum technologies can be observed. In particular, ongoing reforms in cybersecurity field introduce post-quantum cryptography as a goal of regulation and anticipate a gradual transition toward quantum-resistant security solutions in the coming years. So the target for critical systems in the EU is 2030, followed by the wider adoption thereafter. So if we have listened to the representative of IBM, we are a kind of in a safe position. So if we have a target of PQC in 2013 and the quantum computing power will be ready in 2033, so we are very near. We are in a safe territory, but we'll discuss it, I guess, later. So, for me as a lawyer, it is important that the issue of addressing quantum technologies in law is not only one of policy, but also of legal obligation, how I would boldly claim. Fundamental rights, including the right to privacy, impose not only negative obligations on the state to refrain from interference, but also positive obligations to ensure effective protection of rights. And these include the duty to establish adequate prohibitive rules and effective legal framework, both of which remain only partially developed in the context of quantum technologies in Latvia. This can be illustrated, for example, by Latvian criminal law. While it already contains offenses protecting privacy and information systems, as we all know probably, it is worth asking whether unlawful decryption of data should be addressed more explicitly there. A similar concern can be seen in the broader legal framework. In Latvia, even when its law is considered in combination with EU law, the approach to quantum technologies remains fragmented. Clear timelines, roadmaps, and guidelines are also still largely missing, along with the understanding what is specifically required from the society. The situation is only beginning to evolve in Latvia, with the National Cybersecurity Center's first guidance on cryptography released in September 2025, which have been updated just a few days ago. So I invite you to look at these guidelines if you are interested in the subject. They are very informative. Turning to the intersection between quantum technologies and the GDPR. As I noted earlier, and as you know, the GDPR is technologically neutral and in principle can accommodate quantum technologies, both as tools for stronger security, that's what from the Institute two representatives spoke about, and as potential sources of risk. The cornerstone of secure personal data processing under the GDPR is a concept of appropriate measures, and that's also where quantum technologies blend in. As you know, the assessment of appropriate measures should be done in a specific way. It is hard to do that in an abstract way, but still I want to briefly touch upon a few general considerations relevant to appropriate measures. And in particular, proportionality, the state of the art, and continuous risk assessment. At present, quantum-based security solutions, as enablers of enhanced security, are not generally required, as they remain, as I understand, costly, complex, and not widely available. From both a proportionality perspective and the current understanding of the state of the art, they do not yet constitute a general benchmark for compliance in my assessment. However, post-quantum cryptography, as a means of addressing the risks posed by quantum computing, presents a different picture. It is increasingly moving from theoretical development towards standardization and practical deployment, and is gradually approaching what may be considered as a state of the art. I will not dare to go into technical details on this issue. So what does it really mean to implement post-quantum cryptography from a technical point of view? But instead, I'll again refer you to the National Cryptography Guidelines, which explain the basics and provide additional useful sources, including relevant standards. One final aspect I would like to highlight today concerns the requirement for ongoing assessment as a part of the appropriate measures for personal data protection. There are a few key takeaways. First, it is advisable to complete an inventory of all algorithms, keys, and certificates involved in personal data processing now, so that we all, or you, understand what's under the risk. Second, a proper risk assessment should consider not only current risks, but also future risks, especially in light of the shelf life of the relevant data. Long-term sensitive data, such as health records, identity data, financial data, business data, and so on, already falls within the scope of risks posed by quantum computing. To address these risks, post-quantum algorithms should be implemented for the processing of relevant data. And as it is said in National Cryptography Guidelines, it is ideal if it's done within 36 months, so 3 years period. Conclusion. Quantum technologies reveal a growing gap between technological reality and legal preparedness. While technological neutrality provides a foundation for a legal system, it is not sufficient on its own to address challenges of emerging quantum technologies, which is the case in Latvia. In order to comply with its positive obligation to protect fundamental rights, the state must ensure that the legal framework is capable of addressing these challenges, while data controllers, in turn, must already begin considering post-quantum solutions as part of their own security obligations. So that's all from me today, and thank you for your attention. Hope something will be useful and you can take at least part of national cybersecurity cryptography guidelines with you from my presentation today. I invite you to look at them and to study them and try to implement it in your work. Thank you.
Thank you very, very, very much. Next will be Arnis Puksts, who will give a presentation from the perspective of data protection officers.
Okay, hello. Thank you for this possibility to be here. My name is Arnis Puksts, and I will try to show DPO's perspective in this not easy, actually, topic. So, as you see, my thesis is implemented in this image because I believe that DPOs is the only ones who can prevent catastrophe, actually, for this perspective to harvest now and decrypt later. And yes, I have some experience in data protection, so I hope I will pursue you about my thesis, and you will agree in the end of my presentation with that. So the problem, actually the core problem is pretty simple. Quantum computers are expected to break today's encryption, and we know it from previous presenters that it's optimists say it's 45 years from now, so we already possibly be dead, and that's not our problem. And pessimists say, no, it's only 7 years. So how to look at it? Interesting question. This means that the confidentiality and integrity of personal data may no longer be granted in the future. And in near future, in further future, but this is already true that we have from 7 to 45 years. And even more importantly, data that is protected today can already be collected and stored by attackers and decrypted later. So, it's this concept, harvest now, decrypt later. Other words for this is collect now and decrypt later. It's actually possibly here this idea too. And the risk is not only in the future, because it already affects how we should think about data protection today. The good news is that the risk is already recognized globally. We all hear about it here, and not only here, because in the European Union we already have post-quantum roadmap. And migration is expected actually in coming years to be real. At the global level, organizations like NIST have already developed post-quantum cryptography cryptographic standards. And for instance, countries such as the United States, United Kingdom, and Canada also planning their transition. So it is a global shift in how we will secure data in the future. But it's theoretically. But from the legal perspective, we face something like an interesting situation. Both, for instance, GDPR and NIC2 directive are based on a risk-based approach. They both require organizations to assess current and future risks, actually, as previous speaker brilliantly showed to us. And, but at the same time, there is no direct legal obligation to implement post-quantum cryptography. And as you know, everyone is not say lazy, but why we should do something what takes from us resources, time, money, when this is not, we are not obliged to do that. This is philosophy of business, actually. Nothing personal, but just business. Why do something what takes from us efforts if we can just simply sit and look around and wait? And these quantum risks are not explicitly mentioned in these regulations. And I think this creates a gap. The risk exists, but the obligation is not clearly visible, especially for decision makers who may not be aware of this topic at all. I told about topic some days ago to my friends, and no one of them understands actually what about I'm talking. And decision makers are not brighter. They are ordinary people, actually. If you look at GDPR in practice, especially the principle of data protection by design and by default, the situation becomes a little bit clearer. Organizations must take into account risks, include future risks, and apply measures in line with the current state of the art. In practice, this leads to three possible situations. First, an organization may justify that quantum risks is not relevant, for instance, because the data is not sensitive or is stored only for a very short time of period. Second, for instance, if this is bank, this is state register, this is something very important like military or patent register, these organizations may already be aware of the risk and start planning or at least planning or maybe even preparing for future changes. And third, and this is risky business, when there is no assessment and no documentation at all. And I predict that this risky business could be biggest part of all controllers in Latvia, in European Union even, and even globally. And the key point is simple. You do not need to implement post-quantum cryptography yet, but you must be able to explain your decision. why you are not implementing, why you are not even preparing for that. Sorry. And yes, this raises a question: who should drive these changes? Authorities play a very important role. They should provide guidance, recommend planning, and increase awareness. At the same time, data subjects play a role. When, for instance, people start asking questions about how their data is protected in the future, organizations will have to respond. But data subjects actually do not know about the topic at all, or know very, very little. And we should create this awareness. Awareness creates pressure, and pressure drives action. But without awareness, changes will be slow, if it happens at all. Of course, when, for instance, IBM will announce that usable error-proof device is already in the market, then everyone will start panic and do something about it, but it will be too late. And to conclude, post-quantum readiness is not only about compliance, it can also become a competitive advantage. If the marketing understands the topic right, they can turn this into marketing activity. And if we rely only on regulation, progress will likely be very slow. But if we combine awareness with strategy, adoption will be much faster. Preparing for post-quantum cryptography is not only just a legal requirement. It's actually a reality-driven necessity. And in the context, data protection professionals should become advocates for post-quantum encryption, or let's say not advocates, but I could say evangelists, actually. We as data protection specialists, professionals, should be those who comes out, speaks about it with data subjects, with decision makers, and to build this awareness. Because without that, with only recommendations and only scientific approach, we will be at the same situation after, I believe, 5 years from now, if we do not build this level of awareness. And that's all. Thank you.
And thank you, Arnis. And thank you to all of my speakers. So for my quantum newbies understanding, you have provided and touched upon most of the components needed for my equation. So we have a general understanding of quantum computing, so meaning what is quantum computing. We have gained insights into post-quantum solutions, visibility into technological progress as of state of play where we are with quantum computing now, and we have gotten some general awareness of long-term data risks. But for me, the main takeaway from the presentations was that quantum computing is here to stay. It's not about whether we will build a quantum computer, but when we will build a quantum computer. So it's also about the data is not with a question mark, it's about when mark. And that leads me to the discussion part of this session. I heard date 2033, 2035. And I assume it's like a industry standard presumption when quantum computing will be here. But I have two maybe provocative questions. So what are the major hurdles that can hinder to achieve those dates? What are the aspects that are the most problematic that can make the Z date take longer to achieve? And I would ask Andris first to answer to that, if I can.
Yeah, so there's actually a number of technical hurdles. One thing to understand is that to build a quantum computer that will be able to break encryption, we have to go several orders of magnitude beyond what we have now. So if I mean 4 to 6 orders of magnitude beyond what we have, either in terms of precision or in terms of scale of quantum computers. So the most likely way how we would build a large quantum computer would be through quantum error correction, which takes a lot of unreliable components and uses a combination of these unreliable components to build the more reliable ones. So you can think of doing several noisy quantum computations in parallel and then trying to come up with less noisy final result. And quantum error correction exists. There is a number of experiments that have demonstrated it on a small scale. But if we use an error-corrected quantum computer to break encryption, it would have to be a really huge quantum computer. It would have to have millions of quantum bits, in contrast to current quantum computers, which have maybe hundreds of quantum bits. So we are going from hundreds of quantum bits to millions. That's 4 orders of magnitude, 4 zeros added to the size of quantum computers. And at each level, when you go from 100 to 1,000, there is a set of technical problems to resolve. When you go from thousands to tens of thousands of quantum bits, there is a second set of technical problems. And when you go from tens of thousands to millions, there is a third and fourth set of technical problems. So it's not just one set of technical problems, it's 3 or 4 different sets of technical problems that you get when you advance and make your quantum computers bigger and bigger. So it's an enormous number of technical problems. These are problems of addressing each quantum bit individually. These are problems how many quantum bits you can combine on an individual chip. You probably have to go from an individual quantum chip to hundreds of interconnected quantum chips, and then at every step you have new and new technical problems to be solved.
Well, thank you. I understand the complexity while building larger and larger models. But Piotr, maybe you can also provide opinion on that?
Yeah, I agree. Yeah, so when we develop the more advanced technology, we need to overcome more and more problems. From the cryptography perspective, I've mentioned about Shor algorithm, which can somehow broke the keys in RSA protocol. In such a situation, I read lots of articles from different sources mentioning, okay, we need 150 qubits to decrypt the data encrypted by RSA, but it was not proven. Yeah, so it was difficult to verify in the past. But now there are some mathematical doubts if it is possible to use such a small number of qubits. The known, based on my knowledge, approach is you need to have 2 times more qubits than bits in the key, plus 3 operational qubits. So that means that once we will have a quantum computer bigger than 4,000 qubits, almost 1,000 qubits, then probably you will be able to break the keys. And as I mentioned during the presentation, at the moment there is a fight for algorithms. And probably somebody will invent something which reduce the number of required qubits to decrypt such a data. So it is a battle not only in the hardware, but also in algorithms. So, but of course, it can happen or it cannot happen, yeah. Because finding new quantum algorithms is extremely difficult, what is shown looking at the existing ones. So, yeah, this is one of the factors. So that's it. From the other perspective, when I'm looking at how fast the quantum technology is developing at the moment, it seems that we are very conservative in some spaces. In some spaces, we are too optimistic. Yeah. So, again, as a consultant, I can say it depends. It depends, but I think that based on what we present on our roadmap, we are rather more conservative than optimistic. So that shows that maybe it will be possible what we present on the roadmap.
Yes, thank you for your answers. Our Sergejs or Krišjānis can add something about the algorithms and the development of them.
Actually, his colleagues already said to develop a quantum algorithm is very difficult. So there are just a few very important algorithms, and there is a website called Quantum Algorithms Zoo, where you can find I think that all or maybe almost all known quantum algorithms, and only a few of them provide this big computational advantage. So most of these quantum algorithms provide just gradual advantagement over classical ones. And in order to perform these computations, you not only need this quantum computer, but also the related costs. For example, you need energy, you need these fridges to cool down these quantum bits and so on. So in many practical tasks, we still will rely on classical computers. And yes, but if you want to develop quantum algorithms, you have to change thinking. So it's not just classical programming that everyone can use ChatGPT and write an algorithm. You have to think mathematically. And it's very, very difficult. Yeah, you have to study a lot to create a quantum algorithm. But if we speak about these quantum safe algorithms, they are different. They are classical algorithms which can be run on classical computers, and the quantum computers are not able to break them. At least we believe that they cannot break them. But also these classical algorithms which are quantum safe are very hard to develop. There is high mathematics very difficult mathematics inside. And also we have to implement them correctly in classical computers, so to avoid many attacks. So yeah, building algorithms is very time-consuming job.
I want to add on that Andris Sambanis mentioned millions of qubits and Piotr mentioned hundreds and thousands of qubits. We have to understand that quantum computers are very different, and Sambanis mentioned error correction. So probably those hundreds and thousands of qubits would be already error corrected. And computers, they are also very different. There's quantum annealers and scheme-like computers. And the qubits, number of qubits is a rather weak measure.
Thank you. I saw that Piotr wants to make a remark.
I want to comment some statement related to energy consumption. Currently, quantum computer consumes 55 kilowatts, up to 100 kilowatts computing power, energy power. And when you compare this to the GPU servers, 100 kilowatts, it's just a peanuts. So when you have a combination of quantum and classical approach, classical architecture, classical computer, you can significantly reduce the energy consumption using quantum machines, even for the elements and tasks which are also possible to be computed by the classical computer, because quantum computer will be cheaper in some tasks, not in all, but in some. And let's compare this. A regular data center at the moment using GPUs has hundreds of gigawatts, megawatts or gigawatts energy. And when you saw this roadmap, the strongest computer will consume 6.4 megawatts energy. So it shows that it is not only the aspect of how to compute, but also with how efficient we can compute some problems using existing technologies, classical and quantum computers.
Excellent. So planning and preparing and, well, planning again. And we have now spoken about the hurdles. What are the possible accelerants that could push the date sooner? So not 33, but let's say 30. Could maybe AI used to solve some of those error correcting issues? So Andris in his presentation already mentioned the possible use of quantum computers in training AIs. But could it also maybe work the other way around? Yes?
AI is already used in quantum computers in many spaces, in error mitigation and in error correction as well. So we are developing this new approach as well. AI is used also for software developers as a code assistant to prepare the programs for a quantum computer. AI is used for stabilize qubits, because after each and every experiment you need to stabilize qubits and prepare for the new experiment. And this is also done by AI. And there are many more other things, like we use AI in designing chips for quantum. And yeah, probably if I would go deeper, you will find many applications of AI at the moment. For sure, it will, I think that combination of classical HPC, AI-oriented infrastructure and quantum computers is the future of the infrastructure which can deliver significant acceleration in discovery of new things, in discovering in the science.
So anyone else from my team wants to elaborate on that? So if not, my first question is sort of concluded. I will establish that my ZIT will be 2035. And the average mentioned already in the presentations is like a reasonable guess. So taking the hurdles and taking the possible accelerants, we can assume that around in 10 years' time, we will have a quantum computer that will be able to break current encryption models. Not all current encryption models, as we will speak about how long does migration actually take in real organizations, meaning how long would it take currently for an average organization to be post-quantum prepared? So, Sergejs, Krišjānis?
It might be as simple as updating the programming language. It might be as difficult as changing the hardware security model and swapping out smart cards. So the range is very, very vast. One of our partners didn't realize that they were already using post-quantum encryption. So it's happening behind the scenes. And if you're using a cloud provider or a cloud delivery network, they might do it for you.
Yes, and actually, if you use, for example, the Signal Messenger, then you use post-quantum cryptography. If you have an iPhone, then iMessage also uses post-quantum cryptography. So switching to post-quantum cryptography is as easy as updating the software. But there are some problems because many business applications and many business servers run on legacy systems, and they are not supported, and maybe they will not get these updates. And I have worked with some of these systems. For example, some organizations still use the outdated TLS 1.0 protocol, which is considered insecure, but they still use it because they rely on the functionality of the software which was written for that outdated version. So they need to take care of that. But I think that we can, what we can do, we can provide intermediate layers of security. So we take this legacy software, then we build a wrapper, we wrap it with some more secure shell, yeah, it's maybe some proxy software, and then we can use quantum safe encryption. But this has to be done intentionally. It won't be done by its own. And for example, if an organization has a lot of legacy hardware and software, then they should start acting now, because probably they won't get these updates.
Well, thank you. Yes, Piotr?
This is why I mentioned during the presentations that we've already started to provide solutions which has implemented quantum safe cryptography. And I fully agree that business applications at the moment, they are struggling because they have lots of embedded in the code cryptographic algorithm, which needs to be discovered first. You need to do some kind of inventory where we have some vulnerabilities, and then try to fix this. And of course, you need to prioritize what to do next, because there are lots of work in front of us. And another thing is the infrastructure layer, because lots of bad agents on the market, they are trying to just go directly to the data through infrastructure. So also infrastructure components needs to be protected against quantum technology. So this is why we've implemented, for example, as a first device was who had post-quantum cryptography was a type system used for backups, where the backups needs to be stored for tens and more years. So in such a situation, we've prepared our clients to be ready for this new forthcoming technology. And the same is with the storage systems, the same is with the computing elements, like systems who are doing transactions. So even communication internal needs to be secured in these devices. not only applications from the user perspective level.
So, as I understand, how many man-hours would it take to migrate to a post-quantum system depends entirely on the system in use. How many legacy systems are there, what components are there, and what actually needs to be secured. Arnis,
my one additional comment. Sorry for taking so much time, but I think that this is the long life project at the moment, because we cannot assume, take an assumption that at the moment cryptography is forever. So we know that the horizon of that we need to change the cryptographic algorithm in the system is coming. It will be in 9 years, 7 years from today, 10 years, but it will happen. So we need to prepare. On top of this, we are working on new algorithm which can change. Maybe in 5 years from now, these standards will be compromised. And then we need to switch quickly algorithm in the organization. So we need to have crypto agility in the organization. So we need to be prepared to adopt quickly the new cryptographic algorithm in the organization. What means we need to understand what we have. And we need to understand where are the biggest risks in our environment.
Thank you. But I wanted to hear from Arnis what is his data protection officer perspective on what are concrete steps that can currently be taken by basically any organization to prepare. And Piotr has already given at least a partial answer, but maybe you could elaborate on that.
So the first of all is to build the level of awareness. As I mentioned, if decision makers do not understand the problem, some days ago I had a conversation about such simple topic as why we should encrypt the data on hold, because we have very strong environment, our ecosystem is so strong, why we should encrypt data. Such topic some days ago. And if in this situation I will speak about post-quantum encryption, they will think that I speak about fantastic. The biggest problem to my mind now is because we do not understand how long will it take to improve algorithms, for instance, for AI systems with some power of GPU, with only one job to do, simulate and find better algorithm. And we just leave it for day, for months. I believe after some time there would be very nice algorithms. And we do not know how long it would take, but I believe it will not take 7 years.
Okay, I was trying to provoke a slightly different answer because of we already have a responsibility, and it's a good cybersecurity practice to have an inventory of your systems in use. So you can update it, keep it current, and evaluate which systems are ready for post-quantum cryptography, which are not. And that would help you then for that crypto agility thing, which was mentioned, which is a great term. I will use it in the future as well. Would you agree?
Yes, but as I mentioned before, without awareness, without understanding, that's why I told that DPOs is like evangelists. It's very hard to pursue someone that it's could be possibly a real problem, because about, for instance, data on transit, everyone understands that there should be encryption, more or less. But data on hold, there is questions why. And about post-quantum encryption, I believe it's the same story. So the problem is that this is not mandatory. There is no, for instance, one, as we know about GDPR, there was 2018 year. No, it's something like fuzzy. Yeah, you should be prepared in some future, but it's not mandatory to show that you already are taking some steps to be ready.
So noted, we will work on awareness building. And just one small question more for this topic. Maybe you are aware of some tools average controller could use to evaluate his readiness for post-quantum moment that could demonstrate to the same controllers, enterprises that, hey, your system is possibly not ready. Or, yes?
We have such a solution.
Please elaborate.
Yeah, we can identify the risk of in the business applications of from the cryptographic perspective. We also can create some kind of posture of cryptography in the organization and monitor it if there are new methods appearing in the system, or we are just trying to minimize the number of these methods and where it is used. And thanks to this, we can create some kind of, as I mentioned, proxy element, which can create some coexistence of non-quantum safe and quantum safe cryptography in the same solution. So then it is we have a solution which can help to overcome this transition period where we are rebuilding, because this is not from one day task. Yeah. So probably when you need to replace all the credit cards of your clients, it will take months to implement the new way how the card is communicating with the terminal in this more secure way. So such things, I think, requires a systemic approach. But first of all, I slightly disagree with this awareness, because awareness will come when the regulations will come, and the regulations are, to some extent, are cooking at the moment. So at the moment we see some recommendations, but these recommendations will turn into the regulations pretty soon, when the risk of having this technology will be more tangible in the scale we are talking about, just to provide a threat for cryptography.
So, thank you. For me, you want to add?
Yes, so Piotr mentioned algorithmic discovery, and I want to add that observability of which algorithms you already use is very different whether you protect the data that leaves your premises at the infrastructure level, the VPN level, or the application layer. And I would like to add that maybe LLMs could help us scan legacy applications for potential threats.
Well, thank you. I think it's really a valuable addition. And for me, the takeaway is that, firstly, how long you need to prepare for the Z-hour is organization dependent. Secondly, there are tools that can help you, including LLMs and various solutions. And thirdly, it's better to start acting now, especially if you have a lot of legacy systems. And that brings me to the third question, which should help me find answer to the X in the solution. How do you think which types of data or systems already today require protection, while considering that in 10 years the Z tower will arrive? Juris?
So I believe maybe the answer is in the question. So if we are speaking about 10 risks that arise in 10 years, so the data that's sensitive to 10 years is the one that's in the focus. So from practical point of view, I think that, as I already told in my presentation, so we should look at long-term sensitive data, which is under the risk, so medical data, ID data, so financial, not financial, but legal, maybe legal transactions, business data that could fall into category. But again, it's a general answer. I think that much goes into specifics. For example, maybe some kind of, I don't know, maybe some kind of medical data is not so sensitive to harm, and other is. So we should look at specific cases and make evaluation on case by case. Yes. Case-by-case basis, but in general, so long-term sensitive data is the one that's under the risk and under consideration. So that would be my answer. Thank you.
Yes, I hear you, and I kind of can relate back to your presentation and what you mentioned regarding risk assessment. So it's again in the field of the controllers to do a proper risk assessment about what data are they using and what potential impacts the breach of security of this data could have in 10, 20 years future.
Yes, exactly. And I want to stress that this risk assessment, and I guess it's also Arn's told, is core in the GDPR and as a principle. If you're looking forward to secure personal data, so you should make as a risk assessment all the time, and risk assessment includes both looking at the data. That's one facet, and the other I think is this. I think Piotr told about the inventory, or you also told about making inventory of what's under the risk from technological point of view, either it's from infrastructure side or software side. I don't know, I'm not a technical person. So, but anyway, you should make inventory and understand what's under the risk. So yes, and I would also want to stress that it's already a legal requirement under GDPR and under Article 32. It's a technologically neutral and abstract requirement, but it requires to do the risk assessment, even if it doesn't require to implement quantum technologies or to implement post-quantum cryptography now. The risk assessment is a current obligation. Yeah.
Thank you. And I will do a small, loud, provocative math while recalling what was mentioned in Piotr's presentation, that in particular high-value data, which is industrial and medical, should be protected because it will still have high value in 10 years' time. And what Juris just said about large volumes of data, medical data, sensitive data, maybe data about criminal offenses. And for me in Latvia, it kind of sounds like a state actor who should start to evaluate the readiness and preparedness for that. Without pointing fingers, but maybe the state actors should start to take this into account. Yes?
Let's think about aviation industry or automotive industry. So at the moment, these are the digital devices, yeah? And it's the producers need to protect this. And even if somebody stole the data today, fully encrypted, and will be able to decrypt this data in 15 years from now, probably the planes who are produced today will be still in use, and some of cars as well. So I think we should look at this problem from the broader perspective, because I think there are new areas where it will be in danger, which are not so obvious from data protection perspective.
Well, thank you for the addition, and it kind of brings me to the next question. So, core conclusion, and I have to do a quick yes/no question. Do we already live in a world where X plus Y is bigger than Z? So, starting with Sergei's. Yes, no, maybe?
I think no, because Z now is less, but also Y is less.
Christians?
No, because I think Z is actually much larger.
Thank you.
I think that Z is smaller.
So yes.
I believe Z is equal or smaller.
Original answer, thank you.
I miss these X's and Y's. So anyway, I think we are very close to doing practical things in legal side and preparing all what we can prepare today. So we should start doing that today, even if Z was the one letter you were interested, or XY. Z, I guess.
I was interested in a solution of the inequality. So
anyway, I think we should in plain words, we should start preparing for the coming technology, and we should start doing right now. So it doesn't mean that we should need quantum technologies implemented in our businesses or institutions today. But the requirement to think about it, as I previously told, is a current requirement today. So that would be my answer.
So I will count that as a yes. So Andris?
Well, the time that data needs to stay secure is very much dependent on the type of data. So I would say that for some types of data, Z is already less than X plus Y.
Yes. Well, between us, that would be my type of answer as well. But you are 6 people, and I will count 3 against 2 for yeses, because Arnis was like a maybe. And that allows me to bring us to the 5th question about responsibilities. Because if the answer is yes, then we really should start doing something. And who is, in your thoughts, the main responsible person who needs to start to act now? Regulators, industries, organizations? Should Data State Inspectorate be doing something? Please say no. But who wants to take this answer? This question.
I think that Data State Inspectorate is already doing. Yeah, so it's a good opportunity today to speak about it, to speak about the subject, and to raise awareness, as Arnis told. And so it's a good first step. Of course, much should follow. I think that we all are responsible for what's happening with us. But I would stress also as a role of the state, which I wanted to do in a way in my presentation. So I not invented but brought up this positive obligation of the state to act, to make a legal framework that is clear for people, and so that we really understand what we should do. And I think that's also what Arnis told, and I felt it kind of also from Piotr's that we need regulation. It is not like sufficient just to have guidelines and roadmaps and policy documents. I think we should be more specific. So either, for example, we can say in the laws that you should be PQC ready by 2013. It's just a rough example, and we should put it in law and people would start to react to that. Otherwise, if we have just guidelines, it's too soft to deal with a problem. So yes, the state should act more. The state should act more. Yeah, thank you.
Okay, thank you.
I just checked. So we have rather new Cabinet of Minister guidelines now, but rules, minimal security.
Minimal cyber security.
Yeah, minimal cyber security guidelines for and there is nothing about post-quantum encryption. So this is, to my mind, this is the problem. State should act like an evangelist, actually, too.
From a responsibility perspective, I think everybody is responsible who is playing on the market. I think producers of solutions need to provide the solution ready to use at the moment. Organizations need to have at least strategy and inventory and have a clear view what to do when the threat will come more tangible. But for some data, the threat is already, as we mentioned. So for example, where we have long-term retention of data, so definitely we need to apply this post-quantum cryptography right now. When we have vulnerabilities on critical systems, we should identify it right now. And from the country level, I think that there are quite big number of countries at the moment who are working on a post-quantum strategy. And that this is a good move. Probably behind this, after this move, will be the next thing, how to translate this strategy into the action, and how to create some kind of regulations, maybe, at least for some industries. And also industries need to play a critical role, because nobody better than industries understands what are the threats, in fact. So the institutions in NGOs who are working on behalf of some industries, they also need to understand this threat and create some kind of suggestions, recommendations, best practices.
Thank you.
Yes, when we talk about this communication, then I believe that by the year 2035, everyone will be using this post-quantum cryptography, and you have to update your software, because otherwise you will not be able to connect to your servers. So if you do nothing, then you still have to do something by the year 2035. But actually there is another problem, and I think it's more important here. It's digital signatures, because this is a legal agreement, and if we sign some contract now, then this signature must remain valid also after 10 years. For example, if I borrow money from some bank, and currently if we use our existing identity cards, for example, these identity cards and also mobile e-signature, all those solutions are based on classical cryptography. So we have to introduce post-quantum cryptography there as soon as possible.
Thank you. That's a really big fish you mentioned. Andris, you have maybe some thoughts on the responsibilities, who should be acting?
Well, I will agree with Piotr, but a lot of parties have their own responsibility, whether it's providing solutions to someone or whether it's developing a strategy or whether it's developing a regulation. I think it's everyone's responsibility in a different angle.
Okay, thank you. That kind of wraps up the responsibility part quite nicely, because we each can see ourselves in the equation that we can do something and maybe that we have to do something, both as controllers to evaluate our systems and to prepare ourselves, as the state to prepare laws and rules, requirements for security, and yes, as data subjects to be aware of potential problems. And well, I had a sixth question set, which is a policy angle, that should we already start embedding post-quantum readiness into legal frameworks, compliance requirements, or cybersecurity policies? But I think we already answered it in large part. So I feel that I can do a quick final round. What is one concrete step that should be taken within the next 12 months if you are a small, medium-sized enterprise? We'll start with Andris.
Well, understand where you are relying on encryption and which of those things do you need to be replaced, and for which you can rely on someone else updating them.
Great, thank you. Joris?
I guess the answer is very close to that, so you need to make an inventory. And as in the sources which I read, it was written so just a moment, I'll tell it. Yeah, algorithms, keys, and certificates.
Well, excellent suggestion. Thank you. Arnis?
As I told in my presentation, there is three options. Last of them was risky business. Do not do risky business and do whether document why you do not do not act in this field, or you start preparing. It's two choices.
So make right choices. Piotr?
Act now. So I think that first of all, we need to create strategy and assessment and identify the biggest risk from this perspective. And during this discussion, we had a perspective of Western world. And I think this is also important, why we need to act now, because we don't know how fast this technology is developed in China, for example. And guess or not, if somebody will be far ahead comparing to us, they will reveal this or they will try to leverage the advantage and steal the data. Just a question at the end.
Yes, thank you. That's an aspect in risk evaluation for sure. Christianis?
So for data in transit, look into whether your VPN provider or reverse proxy already supports post-quantum cryptography. It may be as simple as switching it on.
Thank you. Great solution. Sergej?
And I would suggest to educate people, educate your staff, educate your system administrators so they are aware about these threats, quantum threats, and also educate your users so they must know why they need to update their software, their Smart ID account, and so on. Education.
Well, thank you. That's great suggestion as well. So we have already 6-step roadmap that each enterprise can follow, and well, there weren't actually that many costs involved. It all, well, logical steps. And we have come to the Q&A part of our panel. So maybe we have questions from the audience. Yes, I see 2 questions.
Hello. I have a question about interplay between this quantum computing and the blockchain technology. Could you please explain this interplay up to the date, and what are their relations, if any? Thank you.
Well, I'm looking at either Andris or maybe, yes, Andris.
Yeah, well, blockchain does rely crucially on cryptography. It's a complex instantiation of cryptographic technologies. So if in this instantiation there are technologies which become insecure, then they need to be replaced as well.
And maybe, yes, Sergei.
Yeah, if you talk about, for example, Bitcoin blockchain, then there is cryptography based on hash functions, and currently those hash functions are not breakable by a quantum computer. Only they affect the time needed to break, but still that time is too large. So Bitcoin won't be broken by quantum computers. I don't know about other cryptocurrencies and all these smart contracts. I think that also they should not be affected. But if you think about money, digital money replacement, then there is an interesting field of research. It's called quantum money, but we need also quantum infrastructure for that. Yeah, but if we have that, then I think that it will be a physical replacement for money.
And yes, the second question.
Thank you for the presentations. I wanted to ask, some of you mentioned awareness and education, but if I'm a regular company, not a regulated bank or hospital, to do some kind of training on awareness, you need to be clear what you're going to communicate to employees, and then they're going to ask, what do you want me to do? So if we're talking about quantum risks, what that awareness would be in education, because as I understand, for a regular company, it's highly likely that the big vendor is going to fix lots of problems for them. So coming back to just education, what should I communicate then?
Yes, maybe Arnis.
It's a very good question. Actually, I do not have an answer to that yet. But I start with decision makers, and if they will understand, then we will find solution. But if they not, they won't give any resources, and without that, how you can do anything? It's almost impossible.
Well, I hope I'm not overstepping and I'm not misinforming, because I hope that we are recording those panels and they will be later on available. So then the first step in educating the people would be show them this panel, and they would have a general first insight on quantum challenges and on how to approach, well, let's say, solving them. Yes.
And one more note, it's a really hard topic to speak about. You see how many of you are there still. So, and you are interested, I believe, in this topic. But when you build awareness, when you are teaching to someone such a complicated topic, it's really hard.
Well, yes, agreeing with you, but I think the main aspect is the place of post-quantum challenges in the risk assessment. And if people understand that what they are not doing has real consequences, then it's probably education enough. But Piotr?
Yeah, I think that the key point is the key decision is on the decision makers, I would say, and the people who are driving the company. Because I can ask the question, do your employees in your company know what kind of cryptography the company is using? Not. It is totally hidden. But it must be understandable by the people who are leading the company. So first of all, they need to be aware, they need to know where are the risks and how to protect this. Maybe you're right that vendors provide the solution and you don't need to take care of this. But if you have a more complex environment, many applications, connections, lots of agents who are connecting to AI agents who will connect to each other, who will deal with your business partners, you need to understand where is the risk. So the assessment, but from the company level, not from the each employee level.
I would like to distinguish two types of data, in transit and at rest. And for in-transit data, you do need to apply these post-quantum cryptography or symmetric cryptography, but for data at rest, we must remember that there's a human factor, and we must encrypt our backups, encrypt our databases, access logs, access control, and so on.
I think we answered. Yep. But thank you for your question. It was quite rousing. It was great. So, any other questions from the audience? No. Then I will go to my questions. So, harvest now, decrypt later. Should organizations already assume that their encrypted data is being collected today for future decryption? Yes, no?
I think it depends on with which country you are trading. For example, I know that in Russia there is a law which forces all internet operators to store this data. I hope that in Latvia that doesn't happen yet, but still, if somebody is very interested in your company, then you should assume that somebody is recording.
Okay, thank you.
I agree with Sergej's, and I think it's targeted, so they don't store all the data because that would be too much.
If your assumption is the worst scenario, then you would be not surprised.
Well, yes.
Actually, I could ask a question about it. So imagine we just had a data breach, but all data at rest was encrypted. And we document this and give notice to state inspectorate that actually nothing's happened. What would you do now, for instance, today or tomorrow about this? Do you ask, will you ask a question about what if?
Well, I don't want to presume, but I would speculate that people who haven't listened to this panel would assume that there are no risks to data subjects because the data set is encrypted and Data State Inspectorate wouldn't know about this breach. So we would not be able to do any suggestions. But if I would have a data breach notification report now about encrypted data being stolen or being lost, I would probably ask for a risk assessment from the controller and about the details of the attack. Was it targeted? Was it not?
Yes, and then to my mind we come to new guidelines, or at least suggestion from the state inspectorate, actually.
So lucky, we already have data breach notification guidelines in waiting. They will soon be ready. I'm not sure about quantum and encryption part there, but we will include them. Juris?
So I would say that yes, it's a risk, and harvest now, decrypt later is a issue that should be considered now. Otherwise, we're not I guess, speaking about raising awareness. So we talked about this problem for 2 hours. So it would be weird for me to say no, it's not a problem. So yes, you should consider that. Sorry, just one idea from the perspective of the state. I don't know whether you took it down in your mind. I think it's a very hard, legally hard to find a solution for that. So I was thinking still about these prohibitive rules and about criminal liability for unlawfully decrypting data. Some things maybe we should consider. I'm not saying that we should do that, but it could be at least a legal solution for that. So I think it's worth thinking about it, because currently there's no offense of unlawfully decrypting data. So, yep, thank you.
Thank you. Andris?
Well, if your data needs to stay safe for more than 10 years, then yes, you should be worried about it being harvested now.
Okay, thank you for the answer, but I will kind of try to build a discussion on that. So, in 10 years, quantum computers will be able to break existing encryption, maybe. But those quantum computers probably will be used by state players and by really big organizations that can afford them. My assumption is, well, correct? First Andris, then Piotr.
Most likely, yes, most likely.
Yes, and Piotr?
Across the world, we have quantum innovation centers where all the players can apply for the resources, so they can run the experiments on the computers, on the biggest computers. So I think this is a matter of national security as well at the end, because this technology is really the game changer. And at the moment, we have access, and the small companies have access, universities have access to this. It's hard to predict how it will develop.
Sergej?
I think that this computational power will be available to those who can pay more. But also, if we speak about the quantum internet, it's not. It will not be available soon. Because of some physical problems that have to be solved. But when it will be available, then combining 10 small quantum computers can give you a very big, a very powerful quantum computer. So even like 10 small players can get this big power. And that can be very threatening, but also this gives more opportunities. For example, we can develop new drugs and new medicine and so on.
Oh, Arnis wanted to add something?
Yes, do not forget about players like China and like cartels, you know. They have resources. And they are smart, because they are now in war with greater country in the world, but as you see, they are still acting, so it's obviously, do not forget about them. And if they will find algorithms, if they will buy or build a quantum computer, I believe they will do not hesitate to use it.
Well, yes, but that kind of emphasizes that you should really be worried if your data is subject to inquiry from state-sponsored actors. And if it's a random black hat who's trying to infiltrate your system and gather data, so then in 10 years' time, probably he is not the problem for the X. And those organizations who feel that they are subject to inquiry from, well, let's say, big players, they should really then implement those post-quantum solutions. Smaller organizations should already also start implementing it, because it's usually the stuff with technology. First you build a big box, which is really expensive, and then you miniaturize and make it more affordable for everybody, cheaper and more accessible. So there will be a Z time when quantum solutions are accessible to smaller players, not just the big state-sponsored ones.
Similar like we had with HPC centers. Yeah? At the beginning there were few worldwide, and the access to them was very limited. And now everybody, it to some extent turned into the cloud model, so everybody can use this kind of resources. So I think this is a matter of evolution.
Oh, and I see from the time we have some 2 minutes left, and I think we can kind of do a wrap-up thing. So maybe a last word from everybody, starting with Sergei.
Be quantum safe.
It is about when, not if.
Act now.
Do not wait, act now, because time is relative in that matter.
So I would add another half, so harvest now and act now. And by harvest, I understand harvest knowledge and act now.
I think we usually overestimate what technology will do in the short run, but we often underestimate its effects in the long run.
And from me, thank you for my dream team. You were excellent and very patient and very knowledgeable. And I ask for a round of applause. And thank you to my audience as well. You were very patient and very great as well. Thanks.